already.
पेपर हो गया my stress, I mentioned this matter because the interim order granted by this court.
Oh, it was not extended on the earlier.
It is up till today. It has to be extended because.
Have you served?
Yes.
You're appealing?
And the matter pending before the SLP, your lordship, I got the 29, it was fixed there. And on 16 September, it is fixed now, before the Honorable Apex Court. So I pray till October, this order may be extended.
When is the next October circuit?
October. 22nd October, I think, in the October, after Puja vacation.
Yeah, no. The last order sheet is not there, isn't it?
20th March order. March 20th.
That's the last order.
I think so.
It was not put up after this. Let it be extended till the end of October. The appellant seeks extension of the interim order granted earlier on the ground that the SLP is still pending before the Honorable Supreme Court and has been, and next date for hearing has been fixed on September.
Yes. 16 September.
On 16 September 2025. Paragraph, heard learned counsels for the parties. Paragraph, in view of tendency of the matter before the Honorable Supreme Court, comma, the interim order granted earlier is extended till 31st October 2025 or until further orders, comma, whichever is right. Yes. Next.
Lord, I am appearing along with the senior counsel, as we have argued, my lord, and the other side.
Yes. Very. Will you come back next week? Next week, madam.
Lord, I appeared before the tribunal in this matter because I instructed, asked the department with a copy of the receipt. They have not said receipt. If my sister can give a copy to me also, so that I will be ready on that time.
Please give it in the course of this day.
Yes, yes.
Since service upon the respondents is not complete, comma, let the matter stand over till 4th August 2025.
Obliged.
Same.
Common, my lord, common issues are important.
Same.
Lord, as per the earlier direction, we have to file paper books, my lord. I filed.
Yes.
But I pray let me fix in next week for hearing.
Is it a short matter?
No, Murad, it is a long, with regard to the reservation of OBC. The fact is that not we advertise on vacancy. There were 43 vacancies are there. Subsequently, when rules have been changed, the ST quota category has been reduced from 12 to 8. So that post has to be towards the, either it cannot go to the OBC because OBC 38%. So 38 plus 8, the remaining person has to be adjusted. So the persons who have been reserved in the OBC category, that post has been reduced. And it has been included in the general category. But after the recruitment process was initiated, so their contention was that once the advertisement is notified, you cannot change the
Change the
policy.
rules during the
Yes,
same
but
days.
in the vacancy notice, it is specifically mentioned. So whether the rules can be changed or the quota of OBC can be reduced, so that is a moot question only.
So this will be next week. I don't think it will be possible. Is
Let it be next
Mr.
circuit.
Let it be next circuit. The council says it is not. And you are the respondent. So he's the appellate. So he'll take a call. It says appeal. Paper books are filed. Copy served. The paragraph, the matter will be placed before the next available circuit.
Right. I received the paper.
Similar issue.
No, no, my lord. This is with regard to regularization. Last week.
Let it appear Thursday. Let it appear on Thursday. Paper books are filed. Copy served. Stop. No? Let the matter appear under the heading hearing on 7th August 2025.
Right.
Let it be on Tuesday. All the matters are being fixed on Monday, right? Let it be on Tuesday. Since service upon the respondents, service upon all the respondents is not complete, comma, let the matter stand over till 5th August 2025.
And 3 of 25.
Let us start with permission, because Lal has been engaged by the respondent in this matter. Ms. Tulsi Lal, she started doing treatment. So I was just praying for that. Requesting. Okay,
Yes, so please give necessary instructions.
definitely.
An adjournment is sought on behalf of learned counsel for the respondent on medical ground. Paper books are filed. Then adjournment is sought. The matter be placed before the next available circuit. On prayer of the respondent, comma, the matter be placed before the next available circuit.
Grateful.
Next.
38 of 25.
All the matters are shifting to Monday. On prayer of the appellant, let the matter appear under the same heading let it be Tuesday, 5th August 2024.
But I am appearing for the respondent number one, the read petition,
I am for 2, my lord.
but I am pressing for hearing of this matter.
Tomorrow,
Let it be fixed tomorrow, my.
fixed tomorrow.
Tomorrow, no, sir.
On prayer of the appellant, the matter is adjourned for the day. Common on.
10 and 11. How about the
Contempt against whose order?
Six and the seven?
So it has to go before please show me the court order under contempt. Order is at page number 32. The order under contempt has been passed by an honorable eviction bench of this court. Paragraph: in view of the above, comma, the matter be released from the list and placed before the Honorable the Chief Justice, comma, High Court, comma, Calcutta, for appropriate directions.
Item 13, WPAP 11 of 11 we have received.
Opposition you've received. Who's appearing for the respondent?
Lord, we are appearing for Andaman Nicobar administration, Lord.
So he's seeking time to file the affidavit in reply. Learned counsel for the petitioner seeks accommodation to use the affidavit in reply as sought. Paragraph: let the matter appear under the same date on 6th August.
NTPC.
Item 40, 30 of 25.
Lord, just not today, Lord. The senior counsel Satadru Chakravarti is held up in another court. But let it be not today, Lord. Tomorrow it comes.
Who's appearing for the petition? You are appearing? You come tomorrow? Or
Just
your
not-
prayer?
No, Lord, that's not today. Tomorrow he will appear.
Yes.
That's not today.
On prayer of the respondent, comma, the matter be adjourned for the day.
Item 15.
Paper books are not ready yet. Paragraph: let the matter appear under the same heading on 7th August.
Item 16, 21 of 25.
Respondent,
Not today, Lord. Senior counsel.
you are appearing for the respondent? On prayer of the respondent, the matter is adjourned for the day. Yes, the past.
Item 2, 31 of 25.
Yes, we have heard it substantially yesterday. You
Yes.
wanted to add further points today. Yes.
You have till the High Court order.
Volume 5.
That's volume 5.
Volume 5.
Yes.
My lord, I want to read this High Court order once again. The petitioner is aggrieved by an order passed by Administrative Tribunal, Kolkata 6624 in OS such and such. By the impugned order, the respondents were directed to consider the appeal of the petitioner within a period of 3 months. Order. My lord, my contention is in the WPCT, the challenge was only for that 3 months period. Whatever challenge was made in the WPCT from my side, there was nothing else. I was not challenged on the merit of the
Nothing
case.
was decided on merit set.
Yes, yes. Nothing was different.
Agree on this issue that was going and coming.
Yes. So 3 months period was only challenged. The three facts relevant in this case are that pursuant to the disciplinary proceedings initiated by the charge sheet dated 31/3/2021, Lieutenant Governor being the disciplinary authority conducted the technical inquiry against the petitioner who was holding the post of executive engineer under Andaman Public Works Department. The petitioner was dismissed from service on 23/7/2022 after due inquiry. The petitioner filed an appeal with the authority after 115 days of receipt of the copy of order of dismissal. The time for filing an appeal before the appellate authority is 45 days. Despite the above and section 19 of the Administrative Tribunal Act 1985, actually directed disposal of the appeal within a period of 3 months from the date of receipt of copies of the tribunal's order. The respondent could not do so. The appellate authority admittedly President of India. Now, my lord, the High Court was offended by the statutory violation of 1904, basically in this paragraph. An application was made before the tribunal by the respondent for extension of time for disposing of the appeal. The application was rejected and petitioner applicant sought to revive the original application. However, in the impugned order, tribunal, while recording the recommendation of UPSC that the punishment imposed on the petitioners was disproportionate to the charge proved, and also recording the recommendation of the UPSC that petition should be compulsorily retired, withholding 30% of monthly pension, the tribunal directed the respondent once again to dispose of the appeal. So this is what which was under challenge in that WP. Why the time was given again? The court is of the view that tribunal has acted in abdication of its responsibility. Once an application is filed under section 19 before the tribunal by reason of subclause 4 of section 19, all departmental appeals automatically abate. This was a clear finding given by the Honorable High Court. The tribunal failed to depreciate the same. The tribunal or simplicity the advice and opinion of UPSC insofar the quantum of punishment imposed on petitioner is concerned. So the coordinate bench was offended by the tribunal only because the 1904 was not effective at this paragraph. So it should have decided on the based on 1904.
That is the decision, that is the recording in this order, the observation of in this order.
This is the first limb is the finding,
Yes.
my lord. The court has offered to the petitioner. This is regarding the penalty which was declined with the observation and direction. With the above observation and direction, writ petition is allowed and disposed of without any order as to cost.
And
Before that, 11, try to pick up the matter on merits and dispose of the same as expeditiously as possible, preferably within a period of 8 months from the date of receipt of the
This
copy.
was not done by the tribunal.
My lord, I am making submission on that now, only on that. My lord, what is on merit? The tribunal is not the appellate authority. Tribunal can facts of the case without the decision of the appellate authority. Tribunal says they are unable to go into the facts of the case because there is no outcome of the appeal. And the respondent, and the applicant is also unable to voice against the outcome of the appeal.
Sir, one thing, this order is not under challenge, right? The order of the court is.
Yes, my lord.
is
Yes, my
not
lord.
under challenge.
So what,
So there is no other option for the tribunal. The tribunal could have either challenged the order.
my lord,
or
let me submit. Let me submit.
And we are.
So what is on merit?
Please submit on
What is on merit?
the issue, please.
What is on merit is not written. What points are to be decided on merit is not written, but definitely it is written that it is not 19.4. 19.4 point is highlighted by the High Court, but other points, what is to be decided on merit? Not highlighted in the High Court order. There is nothing that which point is to be decided. Which point is to be decided? Whether the disciplinary authority's order is illegal or whether the inquiring authorities or finding is illegal. What has to be decided?
On merits includes all.
All point on this, my humble submission is, my lord. Court should not prejudice. This particular litigant is dismissed from service in the year 2022, July 2022. That dismissal was absolutely illegal because I will show a document which it's a legal point. I will show a document which clearly says that if the dismissal is not in accordance with S.K. Kapoor, dismissal is to be set aside. It is a government poem published by
That
government.
has to be decided by the tribunal as per direction of this court.
Yes, my lord.
Whether the dismissal is correct, legal,
But this is point
invalid,
actually
that will
this,
be dealt with by the tribunal and not by this court at this stage.
my lord, my lord.
The issue is very short before this court, sir.
Yes,
This order stares at our face. The order has not been challenged.
my lord. Whether the issue decided by the tribunal, kindly come to the tribunal's order now once again.
Yes.
Order and the challenge, volume.
Yes. Page 90.
Page 19.
The observations are from page 30. Yes.
This is a respondents, the maintainability point which they have raised, 5.1 and 5.2, non-joinder of party. This has been decided by the tribunal that it is wrong. It is not correct and OA is maintainable. 5.1 and 5.2. 5.3, my lord. My lord, it is noted at the outset that respondents have repeatedly failed to comply with the directions of the court to dispose of the appeal of the applicant against the order of dismissal imposed by disciplinary authority. Honorable High Court in WPCT has directed the tribunal to consider the matter on merit. Honorable High Court, while disposing the OA, had occasion to discuss the merits of the case and thereafter writes, our findings in the matter are given in our order dated 6/6/24 are as below.
This is
So
the earlier,
this is the finding. They are saying this finding still remains.
No,
In
no.
this order, they are not,
That order was
they are
set
not
aside.
differing from the finding. They are only writing that our finding is that we still hold good.
that they have
Lord,
not stated. They have only recorded their finding in
My-
the earlier matter, application.
Yes, my lord. Yes, my lord.
They have not stated
Subject
that
to
reconsidered and
subject to your lordship's approval, I am submitting that it is recorded. Our finding the matter, the order are below. So are
Consideration.
no fresh condition. Because there is the order under challenge was only the period. That order under challenge was only the period. One. This was not the challenge in the WP. This has not been actually asked setting aside of this part. Only the previous has to be set aside.
That order to set aside.
Yes, ma'am. Yes, my lord. But they introduce their findings again in this order. So this finding, whether this finding holds good or not, it is subject to your lordship's approval, whether it can be taken.
Cannot hold good in this, in the fresh.
Yes, my lord.
consideration. There has
Then
to be
coming-
fresh consideration.
Coming to the next. So again, this is something new.
Read these submissions yesterday also.
Yes, my lord, I
So
want to
please
just,
repeat your submissions, sir.
no, just I want to elaborate.
You can,
Elaborate. Thereafter, one line is there. No appellate order was passed in spite of repeated directions of this court.
Yes.
This is not there in the previous order.
this is not a merits.
So now, my lord. Now it is based on the coordinate bench judgment. The entire case is taken up. And I would like to go through the coordinate bench judgment once, CAT's judgment, which they have highlighting several Supreme Court's judgment in that. So, my lord, the point is, what remains when the appeal is already abated? That issues were framed. So now, in page 35, whether the stage of consideration of applicant's representation was abated, or second, whether the abatement of stage of consideration will result in a entire proceeding in suspension in the charge memorandum. Then they have supported the coordinate bench judgment of CAT, and thereafter they have come to this conclusion. Ratio laid down by coordinate bench in Shiv Kumar is squarely applicable in this case. In this instant case, the appeal was neither decided within the normal period to decide the appeal. In this case, nor has been decided within the limit set by this court. This is the finding of this court.
This is a reiteration, sir. The
My lord,
tribunal has not reconsidered the issue
my lord,
in terms of the direction of this court.
my lord.
The
But-
tribunal-
But my humble submission is subject to your lordship's correction. This is the issue which was mainly highlighted by the High Court while passing the direction. This is the one ground which was main, and this ground will take away the entire case of the respondent. Only ground, this only ground will take away the entire, because nothing else will be decided in this. If this is taken, this ground which High Court has, so nothing else is required to be decided, my lord. Nothing else. This I am supported with various judgments on this ground itself, because when a proceeding abates, what happens? So this is the law 1904, and this is violation of 1904. They cannot continue for an indefinite period any proceeding, and the litigant cannot be made to suffer for some one word in the technicalities of the order passed by. But the situation will remain same, my lord. My lord.
An ample opportunity to challenge the order of court before the higher forum will be done that.
My lord, my submission before the tribunal is recorded. Submitted everything, each and everything. But tribunal says we are unable to do anything because no appeal is passed.
Not necessary. If
No,
the court says.
that is the
this
view.
kind of merits, they have to decide on.
They
it.
have to,
They don't have an option.
my lord,
Submission, sir.
and I'm relying upon various judgments in the Supreme Court says a tribunal cannot sit as an appellate authority. It can go into the procedural lapses, like in this case, the most important procedural lapse is 1904. If 1904 is considered to be a good procedural lapse, the entire proceeding goes and the applicant is entitled to all the benefits, which are consequential benefits. So That is the spirit of this order, my lord. So tribunal cannot go and decide the facts of the case because Supreme Court has already said in many judgments. There are constitutional bench judgments also. So that is, even if I go, my lord, even if I go to CAT and decide the entire issue, the time extension of time is rejected on 1/12/2023. That is never going to change. They have no option to extend the time. That will never change. Even for the sake of procedural, word of High Court, I may be sent back to CAT.
One word of the High Court is sacrosanct, sir.
My lord, there are
Unless it is sacrosanct.
several judgments of Supreme Court which says that facts cannot be looked into by the tribunal and High
Yes,
Court.
challenge the order.
No, that is not going on facts, my lord. The High Court has not pointed out that factual merits. Merits can be either legal or factual.
High Court has asked the tribunal to decide on the factual issues,
My lord,
which
that
has
is
not been done.
it is not mentioned, my lord. Factual
it's
merits.
mentioned.
It is
Merits,
Why it-
factual facts.
Lord,
What does
why
the
it has
merits
come? My lord, para 9 of the judgment, the Honorable High Court has given its offer saying that the UPSCs, if you accept
Yes,
that,
yes, he has
when he is
refused,
not
he has
accepted, that's why the tribunal, High Court said, you go and decide the merits on merits.
My
So
lord,
this is what the court's view, my lord.
UPSC's
Has reduced, not set aside.
UPSC's
Yes.
reduced.
And you are not
but-
agreeable to that. That's fine.
My
That's
lord,
fine.
that UPSC's objection, it's not record. It's record. I have objected to UPSC's.
You have not agreed to that. That is.
Yes,
legitimate.
yes, my lord, because I am already objecting to that because entire UPSC's objection, advice is also illegal. It is, they
that
say
has to
UPSC,
decide with
they are
tribunal.
saying there is a rule 15 of CCA rule, which 15(3) says the UPSC's advice is mandatory before imposing penalty. Now, my lord, penalty order is also under challenge. This is a law point. Rule says it is mandatory. And rule says it is mandatory. But UPSC says the person who is responsible for that rule to be complied with, he says it is not mandatory. But S.K. Kapoor and R.P. Singh of Supreme Court has said that it is mandatory, it has to be mandatory followed. So this kind
So
of.
we have crossed that stage, right? You have not
My-
accepted the.
Yes, my
proposal of
lord,
the
we have not,
APSC.
I have not
So,
accepted.
yes, yes. So we have crossed that
And,
stage.
and thereafter, my lord, after that, I have filed an ME, which is at page number 804.
Eight hundred and four. Yes.
Eight hundred and four and 868. 868 is another word. ME. No. One minute.
It's a complete relief. So we are
No,
discussing
no.
the entire application.
1 minute, my lord, 1 minute. I want to place some judgments also that may be recorded and pass the
Yes,
proper
please
record.
place the judgments.
My lord, may I say one thing? My lord, without going into the merits of the matter, we are not on the merits of the matter today. We are only challenging the order of the CAT, my lord, based upon the direction which are passed by the High Court in earlier round. My lord, High Court has directed to hear out the matter fresh upon the merits. My lord, once the CAT will hear out that matter on merits, then our appeal truly will lie. Because in appeal court, my lord, this is the WPCT is an appeal, my lord. We have to admit that in appeal court, my lord, appeal court cannot go beyond the order passed by a court below. So, my lord, today we are not upon the facts. The CAT has not dealt with the facts freshly. So, my lord, that's why, my lord, we are challenging the order of the CAT. So, my lord, today it will be futile exercise for the High Court, my lord, to go into the merits of the matter, my lord, specifically in view that the CAT has not gone into the merits of the matter and, my lord, dispose of the matter, my lord, just technically, my lord.
Yes, what are the judgments that you're relying upon?
My lord. This abatement, starting from abatement, what is abatement?
Yes.
Come.
Yes, paragraph.
My lord. Here, page number 9.
Yes.
Before that, F also is there. Relying on its own decision, you thus Union of India, the tribunal has held that employer not having employer,
Reading.
last line of page number 8.
Keeping these factors in mind.
Page number 8. Page number 8.
Yes.
Relying upon own decision of you thus tribunal has,
Keeping these factors in mind. Last line
That-
of page number 8.
that is page number 9. Keeping this factor is page number 9, I think.
Here it's page number 8. Relying upon is page 7.
Okay. There is some mistake.
Yes.
Relying on own order, tribunal held that employer not having completed the disciplinary proceeding within the time fixed by tribunal, where order dated not such proceeding must be deemed to have been abated.
This is a disciplinary proceeding that was completed within time in this case.
My lord, I'll come to appeal stage also. This is,
But so this is not applicable.
so this is, they are writing next two paragraphs also. On the background, tribunal caused the penalty order and had directed the ministry to pay the officer all consequential benefits within the time of 2 months from the date of. Other thing apart from the matter of delay in concluding the proceeding has been addressed lately, Supreme Court in judgment dated such and such. So they are saying in Supreme Court has already held that the time period has been fixed by the Supreme Court. It should not be beyond that
For disciplinary proceedings.
disciplinary proceeding. So this is basically, these are the judgments which are for disciplinary proceeding. I now come to the time limit fixed by Supreme Court for appellate proceedings. So there are 3 to 4 judgments on this point. I will give for the
But this is
discipline.
not applicable
This
in
is
this
not-
case.
I will show
Because
the.
disciplinary proceedings were completed within due time.
Yes, ma'am.
Yes. Paragraph.
This is the constitutional bench judgment. 1950. It is I am referring page number 9 and 10 of this judgment. Here, we are, the question of consideration of whether it should be disposal of one appeal or the entire hierarchy of relief as may be provided, may have been provided. Statutory guidance is available from the provisions of section 2 and 3 of section 20 of Administrative Tribunal Act. There, it has been laid down. This is 22 and 20B. This 20 is quoted here. We are of the view that cause of action shall be taken to arise not from the date of original adverse order, but on the date when the order of higher authority where a statutory remedy is provided, entertaining appeal or representation is made, and where no such order is made, though the remedy has been availed of, a 6 months period from the date of preparing of appeal or making of representation shall be taken to be the date when the cause of action shall have taken to have arisen. We, however, make it clear that the principle may not be applicable when the remedy available of has not been provided by law. Repeated unsuccessful, this is what they said. So 6 months period of order limit is fixed and it is reiterated again.
They say that the cause of action
So next page,
shall be taken to a first arisen. So they don't, this judgment doesn't say.
next page.
Yes.
It is proper that position in such cases should be uniform. There is every such case only when the appeal or representation provided by law is disposed of, cause of action shall first accrue, and where such order is not met on expiry of 6 months from the date when the appeal was filed or representation. The 6 month period is given for appeal to be decided and filing an application. So the time cannot be as per this order, that is the fixed time. And then, so this is the fixed time at the appeal. Appeal has to be decided within 6 months. Because there is no time, further time is given by the Honorable Supreme Court to decide the appeal.
That is settled in this case. That within 6 months it was not done.
Yes, ma'am.
Another 3 months it was not done. That is all settled.
So that is what I am giving the High Court judgment, which says about the time given by Supreme Court of 1 year. Within that, if it is not settled, then the proceeding is abated. So that is what I'm saying, that just correlating this two. I'm not saying anything else. So now I have another judgment.
Hmm. Yes.
In this case, I am just reading the paragraph 5 at page number 3.
Paragraph 5.
Page number 3.
Yes.
Now, my lord, more than a decade have gone since these employees were dismissed for participating in strike by union, but end has not reached. Barring Appellate and revision authority, whose discretion too was attempted to curtail by issuing circular, no court or tribunal has found the orders to be well founded on merits. True, the jurisdiction exercised by High Court under Article 226 or the tribunal is not as wide as it is appeal or revision, but once the court is satisfied of injustice or arbitrariness, then the restriction self-imposed or statutory stands removed, and no rule or technicality on exercise of power can stand in a way of rendering justice. We are not expressed by the Government Commission of Learned Additional Solicitor General that CAT Hyderabad exceeded its jurisdiction in recording the finding that
This supports the petitioner's case.
no, my lord, my object of the Tribunals Act is to give speedy relief to the government's party. And in compliance with that object, 19(4) is thoughtfully inserted by the legislature, saying that if the that 6 months period is prescribed, if you read section 19 and 22B, the 6 months period can be made up. And thoughtfully, it was given 6 months period, and it is given in the act itself. But if the application is accepted, then all proceeding pending proceeding abates. In the act itself, it is given. There is no, there cannot be any deviation from that. So the Honorable High Court has said that to decide on merit, but High Court has not said.
This judgment also says so, sir. If
No,
it
no.
is not decided by the appellate authority, the tribunal can decide it on merits. This is the judgment.
Yes, my
paragraph
lord.
5.
So this is on merits, but the point is 14, 19, is the valuable right. That 19(4) is the valuable right available to the petitioner,
We
my lord.
submitted that, sir.
Petitioner.
We'll
So
consider.
that cannot be taken away without any other law enforced.
We'll consider.
19(4) is a valuable right, my lord. And thereafter, this abatement has been decided, my lord. In other citation. What is abatement? Exactly. Whether the abatement at the appeal stage is whether the abatement only for the appeal or for the entire proceeding starting from it. That has been decided by the Supreme Court.
That is again 19(4), you say.
Yes, my lord. I am saying that this 19(4) right, which has accrued to me, it will never change. Whatever merits can be taken, this will never change. Even now, if tribunal decides it on merit, then also this 19(4) right will never go away. I am entitled for all benefits, my lord. My lord, I am entitled for all benefits from the day one. From the day one, I am asking for an interim. First dismissal was illegal, and Government of India has published a note saying that such illegal dismissal should not happen, and if at all anybody has done any dismissal, has taken this decision, then immediately the employee given provisional pension. That was my first case before the CAT tribunal, my lord. I was asking for only provisional pension. Let the proceeding continue. I was asking for that. That was my first case. And in the CAT's judgment also, Honorable Tribunal's judgment also, it is recorded that if the petitioner seeks for an interim relief, that will be considered by the appellate court. So while filing the appeal, I have taken a specific plea that my interim relief be given because the dismissal order is expressly illegal. Disciplinary order has not procedure is not followed because UPSC was not consulted. That is my case, and they have admitted in their reply also that was not done. It is not that is not contested.
Did you take any steps for disposal of the appeal within the stipulated period of time?
Yes, I approached the tribunal. Tribunal gave them 3 months time. Tribunal gave them 3 months time. Then again, it was not disposed. Again, I approached the tribunal. They did not come. 7/7/2023 was the date when the tribunal issued an order granting 3 months time to them. That is after 6 months. Again, another 3 months was given. Somewhere in December, they came with an application for time extension. It is recorded in the judgment of tribunal. That time already my weight was and taken in. So therefore, that extension of time, which was also filed delay after delay, it was rejected. It was rejected. It was rejected on 4th of December 2020, my lord. My lord. So after 2023, actually nothing remains to be litigated in this matter because 19 is silently applicable. So now the only issue is my interim relief. Neither the appellate authority decided my interim relief. In the first round of litigation, it was not decided. And second, round,
But you've been given final relief, sir. Interim
Yeah,
does not
final-
require any further.
because it was an
It
interim,
was disposed of.
it was the interim relief. Interim relief I was seeking in the OA. That was not given, and ultimately it was given after 1.5 years. I was given final relief. That after coming to the High Court. High Court, and now I was given. And till date, what the submission was before the tribunal is para-wise reply is being prepared by the Vigilance Department of Administration. And in this writ petition also, the same paragraph is copied, and they are saying that paragraph wise reply is being prepared in the Vigilance Department by the authorities. So now they are not taking any action for sure, but I am not being given my provisional pension. So my humble.
So now this is pending. So
My-
there is no
my-
question of a
my
provisional
lord,
pension.
my humble prayer is, if at all this matter is remanded back, I may be given the provisional pension. Because it is excessively illegal, I can show that order where the government of India says that provisional pension is to be given. If it is remanded back.
Well,
It is a law point, my lord.
we'll resolve this.
My lord, it is a law point actually, that I can, one document is enough. It is there. OM is there of 2016. If this procedure is not followed. So only my prayer is, if at all it is again delayed, because tribunal comes only after 3 to 4 months.
We'll look after it. We'll look in. We'll look in.
My lord. Grateful, my lord.
Argument concluded. Judgment reserved. And
Great.
Lordship, I want to mention item number 5. Yes, I give it fair, Lordship, but obviously she could not submit submission. Your
what's
Lordship.
the order passed?
Next circuit, Your Lordship, already matter has been decided. Matter has already been decided in the last circuit.
We were told that it's a very lengthy.
No, Your Lordship, already decided matter. In the last circuit, this has already been decided. That's not the issue.
Malad, the matter was decided on last circuit, but the thing is that Malad, all these things were not gone into whether the judgments passed by the Supreme Court in various of the cases where cadre has to be maintained. Those things are not been looked into in those judgments. So we have to Malad, argue it again, Malad. And Malad, the thing is that in item number 5, Malad, Union of India has not been made party. It's our mistake. So, Malad, we are also Malad, seeking liberty of this honorable court, Malad, to make Union of India a party, Malad, because it was party before the cat, Malad.
Unnecessary.
Today, Malad, I have just noticed that Union of India has not been made party, Malad. It's a necessary party, Malad.
My client is the sufferer Your Lordship, because of their delayed conduct. She is not getting the money.
This one, come.
Your Lordship, they are saying that Union of India, they have not made a party to the case. At least let that order be passed. So, in the, yes,
Yes,
other-
that liberty, Malad, may be given, Malad, to us. We shall make Union of India a party and serve them.
let it be recorded, Your Lordship.
Can be added to that order.
My lord, my lord.
Petitioner, you are the respondent, right?
Yes, Your Lordship.
On prayer of the petitioner, liberty is granted to implead the Union of India as added respondent to the application.
Grateful. Great.
Yes, Lordship. Otherwise, in the next circuit, same prayer will be there.
Aye.
Obliged, Your Lordship.
Well,
Client is the resident of Hatton, including Western, we filed today, tomorrow is finished.
Supplementary list. Who is appearing for the other side?
You know, so understand all the things. I'm getting the stay of that, Mr. Tomorrow is the detention. I am satisfied with it.
Supplementary list.
Obliged.
Lordship, I may be permitted to mention on that. Readings are completed in this matter. I pray let it be list before we spoke,
When? Wednesday.
when
Wednesday is sixth.
Lordship,
Item number 1.
Yes. Petitioner,
Lordship, I am for the respondent, Lordship.
petitioner. No one.
Yesterday, Lordship, arising out of same affair, one revision was filed by counsel came from outside of Port Blair. That matter is fixed tomorrow. So this is a
Let this
anticipatory.
also appear tomorrow in that.
Lordship, it is anticipatory way. In the meantime, case diary may be called for. Required. Lordship.
The case diary will be required.
Yes, Lord. But petition is,
No one for the petitioner, none appears for the petitioner. The matter is adjourned for the day. Case diary be produced on the adjourned date.
yes.
Next.
Item number 2. WPS 330/25.
I put the petition. Yesterday the matter was fixed. That regarding the payment of, releasing of payment. As the contractor has completed his work. And in spite of giving the notice, they are not releasing the amount.
Who is appearing for the response?
Yesterday, Mr. Rakesh
Mr. Rakesh Kumar was there. Yes, where is he? He was here in the morning. A very small issue. The Panchayat Pradhan. Rakesh Kumar. Thanks, Rakesh Kumar. Mr. Rakesh Kumar. It's a very short issue. Come back tomorrow.
Yes.
And none appears for the respondents. The matter is adjourned for the day. Please inform him.
Yes. Right. It will be fixed on Saturday, your lordship, because I believe Friday is holiday, maybe a holiday, so it.
No, there is no notification of a holiday.
Yes, I'm ready for, no.
Friday is working, Saturday is also working. So come back tomorrow. Let's. Yes, next matter.
Item number 3. WPS 320/25.
Lordship, I am for the petitioner. Service has been effected, Your Lordship, on 29. Affidavit of service is also filed.
Who is appearing for the respondents?
Generally, Mr. Rakesh Kumar used to appear for municipal council. Today, I don't know why he's not here, not
He
appearing.
was there in the morning. Is he before the other court?
I'm praying for an interim order also, Your Lordship, in this case.
Please come back tomorrow. Will you inform him, please?
Yes, Your Lordship, I'll inform him and I'll come back to him.
Affidavit of service. He should be representing all the respondents, isn't it?
Yes, Your Lordship, because Herbal Municipal Council is the actual respondent.
Yes, yes. Affidavit of service filed by the petitioner is taken on record. None appears for the respondents despite service. The matter is adjourned for the day.
Your Lordship,
Please inform.
I'll inform.
Next.
Item number 4. WPS 353/25.
My lordship, in this matter, Jayapal sir is appearing for writ petitioner. I praise for short passover. He's in court number 2,
Let him come.
4 and 5.
Yes, Mr. Rakesh.
Sure, ma'am, I was elder than that. I'm sorry, Lord, it can be taken up now.
Which matter will be taken up? First one.
Ma'am. The item 2, my lord.
You have the report.
My lord, I have taken instructions, my lord.
Three.
No, 2.
2 is also his one. 2.
I'm sorry, my lord, I'm for the petition.
Yes.
My lord,
What is the difficulty? Why was the payment not made?
Lord, it is related to work for fixing the street lights and it has to be cross-checked by the concerned junior engineer whether the standards which is given has been fulfilled or not. My lord, it is under process. What I suggest, my lord, let it be disposed of with certain time limit. We will consider his representation notice is paid over 14. Because he has not enclosed the bills. The bill has to be verified. My lord, I take instructions.
All
with
the
regard to
bills were submitted before the concerned authority.
But it has to be countersigned by the junior engineer, my lord, of the concerned village. The contract is specifically mentioned.
You need to have a completion certificate or something of that.
I already submitted before that.
Where
So
are the copies?
actually, the contractor submitted the original documents. He said not.
So let me give a direction, let me dispose of the
Yes,
application,
yes,
directing them to consider your claim within a month.
yes, Your Honor. And you are not, sir.
Yes.
The interest also. I'm not paying for interest also.
When
Because I have
completed,
completed in the year 2023.
when did you submit the documents?
Immediately after completion of the
That is
construction.
Where are those documents, sir? Those should have been with the record. Isn't it? You say there's a delay on the part of the authority. You need to show
That
that.
manner, Your Lordship, let him file that I have not I have not completed my work within a time.
It's your claim, you
Yes.
have to substantiate your claim with the documents.
Then Your Lordship, at least a liberty may be granted to the petitioner to file a appropriate application before the concerned authority for releasing the interest.
You have already filed an application, I think.
I have claimed you. Because I have expended lot of money at that time of the construction one. And after 2 years, now they are ready to pay, the concerned authority is ready to pay the work amount. That is not a good value.
Let him file a comprehensive representation before the authority, let the authority deal with it.
Yes.
And find out what amount is due and payable and let them clear the amount. For learned counsels for the parties. The learned counsel for the petitioner submits that the petitioner is an AMC contractor and was allotted the work of repair of street lights, repair and maintenance of street lights by a work order issued on 5th September 2022 by the Pradhan, Gram Panchayat, Harinagar, Andaman and Nicobar. Though he completed the said work sometime in 2023. You completed in 23.
He has not mentioned when he has
There's
completed
nothing
also.
in the.
He has not mentioned when he is.
Please do this. According to the petitioner, he completed the work and submitted bills in 2023. The payment is yet to be made. Stop. The petitioner seeks to submit a comprehensive representation before the respondent, annexing copies of relevant documents, right? And place for a direction upon the respondent to consider the application at the earliest. Paragraph: in view of the above, liberty is granted to the petitioner to submit a comprehensive representation before the respondent Within 7 days, annexing copies of relevant documents within 7 days from date. Stop. The respondent shall deal with the. I have cited application and representation. The respondent shall deal with the representation and dispose of the same within 1 month from the date of receipt thereof. In the event the respondent is further directed to, please strike out in the event. The respondent is further directed to clear the dues of the petitioner within the said date.
And if it's found to be in as per the work order, the specification of that. Because work order is 5/9/2022.
Within the said date, upon verification of the documents submitted by the petitioner and satisfaction with regard to completion of the work in terms of the work order.
But as no
If the
affidavit has been
above-
called for that allegation raised in denial.
Yes,
No affidavit has been
yes,
called.
yes, yes. With the above observations, observations and directions, the writ petition is disposed of. Since no affidavit has been invited, the allegations made in the writ petition are deemed not to be admitted.
Obliged.
Obliged.
Next, it is another passed over matter.
Yes, yes, madam. Copy दिया जाएगा. Copy तो मिला नहीं. ये कब फाइल किया गया? सर्विस हो गया. पुलिस को प्रॉब्लम है ताकि नहीं.
Yes, but two was.
अच्छा ये वही मैटर है जिसका वो जेई का डिसिप्लिनरी प्रोसीडिंग फिर से किया था.
In 3 also he is appearing. No. Mr. Rakesh Kumar is not in 3. He's in 3. You're in 3 also? Yes, yes.
I not got the copy. But take a copy. Not today, then tomorrow I will make my submissions.
It's urgent for the day.
I request copy.
Please, I said, 3 I
Yeah.
stated that the respondent does not appear, I think. Please strike that out. On prayer of the respondents, the matter is urgent for the day.
Obliged.
Next,
Item number 4. 4 and 5 is taken upon. Starts the copy of the institution.
oh, you have not received the fact report. Since service upon the respondents is not complete, let it be on Tuesday.
Yes.
Let the matter stand over till 5th August 2025. 4 and 5, same order.
Item number 6. W3 177 of 1025.
But this matter may be taken up on Tuesday, my lord. Why? Because I have been acquainted with the client previously when I was not inducted as a panel. So I instructed to engage some counsel to be appear on behalf of the administration. So let it be on Tuesday, my lord. It is already under process.
You're
Sir
the
has come.
petitioner.
My lord, they have put the respondent.
Earlier day also you sought.
Yes, yes, then Mr. Senior counsel is there, my lord. He will make. Sataru sir will.
But my lord, somebody advocate on record is to be appointed, my lord, because so
let-
it can, I don't know if the petitioner is not insistent, it can go to the next circuit also, my lord. I don't know what the petitioner is saying, my lord. The petitioner, whether they are.
Yes. Tuesday. He's asking for Tuesday.
Yes. my lord.
Learned counsel for the respondent seeks accommodation. Let the matter appear under the same heading on 5th August 2025.
My lord.
Next.
Item number 7.
Lord, I am for the petitioner for appointment of arbitrator. But the respondent
served?
company is in Bangalore, my lord. I dispatched.
Not
Shows that not at served.
next week.
Next week,
Tuesday,
any
Tuesday.
date, any date.
Since service upon the respondents is not complete, let the matter stand over till 5th August 2025.
Obliged.
Next.
Item number 8.
That's what they responded, Lord. As per the direction passed by this court, I have filed the writing, court loss.
The copy may be served to me, my lord.
Have you served a copy?
Lord, Lord, this be taken in next circuit, my lord, because I am appealing through SLSA. Client is in Camel Bay, my lord. I will talk over phone and I will send it on WhatsApp. Let's see if he intends to make any exception, then otherwise it can be aired out on.
A report in the form of affidavit submitted on behalf of the respondent is taken on record. Copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph on prayer of the petitioner, liberty is granted to use an exception to the affidavit, comma, if required.
Yes.
On his prayer, comma, the matter be placed before the next available circuit bench.
Oblige me.
Next.
Number 9, WPN 9 and 2 of 103.
Yes. You have received a copy? This one on 4 or 5? She's 5, I think. You are 1 to 4. So you're ready for the hearing? Let it appear tomorrow. Let us see. Affidavit and reply filed by the petitioner is taken on record. On prayer of the parties, comma, the matter is adjourned for the day. It will appear under the heading hearing. No? No need to mention here, but please keep it under the heading hearing. Hearing. It's appearing as hearing. It's already appearing as hearing.
Item number 10.
I'm for the respondent, my lord.
4.
The judgment part is left, right?
Yes, this is just something I want to show thereafter judgment.
इजी करेगी फिर हम करेंगे टाइम लगेगा तब तक हम वहाँ जाके टाइम लगेगा
Yes.
Because the family terms is based on the 7 of the results.
87 dB
87.
Yes.
Yes.
You know, if you kindly see, this is a house site.
Yes.
Regulation 159(9) of Andaman and Nicobar Land Revenue Act. The property, the non-agricultural property, then the permission from the restrictions. That only I wanted to say. Because the version that the statement which I have mentioned, that Rajaram has said that sale permission is required and he has applied for the sale permission. I wanted to show that this is a house site and for house site, sale permission
Is required.
is required. I'm just reading it, 159(9). The interest of a license of a non-agricultural land shall not be transferable except with the previous permission in writing of the Deputy Commissioner and subject to such terms and conditions as may be specified. This is 159(9).
Do we have the rules?
Regulation.
Yes. This is a very frequent affair in Andamans now. Last time this was not like this.
It is horrible right now, my lord. Out of 24 hours, we don't get even 6 hours electricity.
After privatization, I believe.
First judgment is Ratnavati and another versus Calcutta and Shah. Thank you, Darshan.
Yes. The relevant paragraph?
Yeah, Your Worship, the relevant paragraph is 44 to 52. The main one is 46. Forty-six, 47, 48, Your Worship, those are the correct paragraphs. 49. Here reading of Article 64 of Limitation Act which show that if the date is fixed for performance of the agreement, the non-compliance of the agreement on the date would give a cause of action to fight suit for specific performance within 3 years from the register date. However, when such date is, no such date is fixed, limitation of 3 years to fight a suit, specific performance will begin when the plaintiff has noticed that the defendant will complete the performance of the agreement.
That is the second link of 54 limitation.
Yes. Now you want to go back. That's everything. That though I had mentioned in my plain introduction that it was July 2017 that was refused. 16, this honorable court will also the honorable Supreme Court of also said that if the time has to be gathered, this honorable court, any court can gather the time by looking into the pleadings of the party. The pleading says, Your Worship, that in 2016, I have submitted July 2016, they have refused. Even assuming for argument's sake that that date is not considered. The date which can be considered, Your Worship, would be of 2015 when petition took place.
And here 2000 has been considered.
Yes.
You've stated that.
Yes. So 2015 would be, even if assuming for the argument's sake that July 2016 is not considered to be the date of petition. But 2015 has to be considered because that is the date only on which date they got the land mutated in their name. So if we start from 2015, and I find this would be 2016. Now you watch the next judgment. Panchal and Dhara. Next paragraph 21. 19 and 21. Again, Your Worship, the court was very clear about the point of how the period is to be calculated. I'm not reading, Your Worship. This is how it is to be calculated in the facts and circumstances of the case the court has discussed it.
Yes, sir. Have you provided the citations to?
Those who are there, but this one possibly is unreported, so I might not have narrowed them right here.
I will give a call.
This one, Your Worship. This is of this honorable court, Your Worship, where I have taken the point of limitation. And this honorable court has discussed a number of things. And basically, the court has considered the judgment of Ahmad Sahab Abdul Mullah, which is very relevant. Because what I have seen the entire judgment, this Your Worship of this, the other side which has been annexed. Where, Your Worship, the date of refusal. A reference was made before the honorable free bench of the honorable Supreme Court with regard to the date of refusal. Now, I have not specified exactly the date in my suit. It's true. I have mentioned July 2026. Now, Your Worship, this was practically discussed, Your Worship. That is.
It's not paginated. No difficulty. Tell me which page is it?
5th page.
Yes.
On the aspect of limitation, the defendants rely on a decision reported in 2009, volume 5, SC 463. In that case, a reference was made to a three-judge bench of the Honorable Supreme Court as to whether a date referred to in Article 54 of the Certificate of Limitation Act applied a specified date or not. It was in such context the Supreme Court opined paragraph 11 of the report that the word date implied a definite date. Whether it was for the first name of the article or the second name. The judgment is not an authority for the proposition that a plaintiff seeking to apply for specific performance of an agreement for which there is no specified date of performance has to stipulate that exact date when the plaintiff's demand for specific performance is refused by. coordinate bench has taken a decision with regard to that aspect election. Because what I find, I was thinking about that judgment only, because I have not specified the exact date. So this particular thing has been discussed by this honorable court in another second appeal. And thereafter, the limitation ground was not accepted by the court with regard to the limitation point. There are a number of other things about limitation discussion has been made. Then it has also been held that limitation when it is submitted, when a particular thing is written in claim itself, that on this particular date the time starts running, then it is for the defendant in the written statement he should state, no, it's not that date, it is this date. That discussion is where to make. Here in this case, they have denied the existence of the agreement itself. And they have never stated that on which date the refusal actually took place. They never stated so. So that discussion is there in this judgment.
Yes.
After this, just next page. Limitation is a matter of discussion.
Yes, I've seen that. I've
Yes,
seen
that
that.
particular paragraph clearly described.
I've seen.
Then your lordship, Lakshmana versus Jayama, your lordship. Thirteen to 22. Again, facts were narrated, your lordship. There was a delay, but then again, the time was not the essence of the contract, and thereafter, your lordship, it was decided in that. Well, your lordship, this judgment, your lordship. There was a delay of 29 years in filing this suit for specific.
Also, is going to be.
Only one card, yes, official. Only one.
Right.
Paragraph 7, 10, 11, 8, 10 to 12. That's the direction. These are the judgments, your lordship, and the judgments which are the copy which has been sent to me. I have looked into all the judgments, your lordship. The first one is Parakunan Bekti Joseph Son Maggie. Your lordship, this is here, your lordship, I have marked it also. Here a person has waived his right. There was a specific decision by the Honorable High Court, Supreme Court, that there which is mentioned, since Chettiar, paragraph 40, last page. The chief anchor of the suit by Varghese is the agreement for safe exhibit A1. Since Chettiar has waived his right there and there, Varghese had as an assignee could not get a better right to exist. So that is completely
Different.
based upon a different.
I just place the punch, my lord, of my judgment, so that my lord can refer to the.
Now you also, that was the first judgment, you also, page number, last page, for instance.
Page
That judgment,
mark
the
here.
last page.
Page
the
5,
five.
mark here.
First judgment.
Yes.
Now, second judgment, your lordship, page number 7, kindly see, your lordship. As per that agreement, the first paragraph, just from the bottom, third line. From the bottom, third line, page number 7.
Yes.
As per the agreement, the appellant was to execute the sale deed on or before 16/1/1970. In the agreement, time was mentioned.
Yes.
This has also got no application option. And there, the concept of undue hardship has been explained. But this, the Honorable Supreme Court has observed that in the pleading, in the written statement, the hardship has been explained in detail. And thereafter it was adjourned. The next one, Your Lordship, is this, page number 12.
Yes.
MSR. That, Your Lordship, I am directly connecting it to that terms of barrier. Where this honorable coordinates with has held that it is not an authority to the proposition, that even in case of refusal, the date has to be specified. Paragraph, because that reference was specific to that effect. Reference was only when the date is fixed, where the date has to be mentioned. That was the reference. Now, page number 16, the next judgment.
Yes.
Page number 26, paragraph 20. Here, Your Lordship, the kindly see just 10 lines from the bottom of paragraph 20. The intention making time of the time essence of the contract for payment of balance price is clear from the following. Clause 4 requires a balance concession to be paid in installment, 1 lakh on this, 1 lakh on this, 25 on this. Clause 5 if any of the above mentioned dates of payment is subsequently declared as audit, next immediate working day shall be the date of payment. This shows a clear intent payment should be made on a stipulated date, and even dates delay was not acceptable unless the due date was declared to be. So dates were fixed. Here also this statement is also the facts are different because dates were fixed. Then we also
40.
also page number 44, last paragraph.
Yes.
During the course of evidence, the applicants produced material indicating that the value of the property was 6,30,000 on this. The agreed consideration with the parties was rupees 1,60,000 on which an amount of rupees 60,000 was paid at a time of execution of the agreement. The sale transaction was to be completed within 3 years against the payment of the balance rupees of 1. Again, here also, after payment of 1 lakh, within 3 years, it is to be registered. The appellants also relied upon exhibit 2, which indicate the value of the property as on this. These aspects were adverted to in the judgment of the trial court.
So time was there. It
This was the essence. Even in this case, time was the essence. Now, page number 46. Again, you should say, page number, paragraph 21. Page number 46, paragraph 20. Here also, your lordship, just 3 lines. It is an exceptional position that 1 lakh was paid at the time of execution of the agreement itself, and the balance consideration was required to be paid by 26/5/1918. The specific time was mentioned. So the court has said, if we take the date 26/11/1989, the date of performance, the suit was filed by on this is barred by elimination. Because date was fixed. That on this particular date, you have to make the balance clear.
Yes.
Page number 54, your lordship. Page number 54, page number 60, paragraph 15.
Yes.
The ratio of the above judgment in all force would be applicable to the facts of hand in the instant case. The agreement of sale was executed on 7/6/1993, and the date fixed for execution of the sale was 1 year from the date of measurement of the suit schedule. Again, time is there. Undisputedly, no such measurement was carried out, and the plaintiff has not raised his rinky finger in this regard from the date of execution of the agreement till he got legal notice dated this, and this is almost for a period of 3 years and suit came to be filed only on this at the fact and of the expansion of limitation. Again, time was fixed. Then the next judgment, page number 61. Relevant is page number 70, paragraph 31.
39.
31. As per the elements made in plain, the respondent claimed it did not even once during the appropriate period of 16 months approach the apparent defendant for getting the saving executed in terms of the disputed agreement. He claimed that he stated the procedure to the sub-register office of this and remains present from this to this, waiting for the apparent to turn up and get the saving registered. However, the apparent failed to appear at the office of register on the scheduled date. A typical response did not give any advance information to the apparent, including when to receive the direct message to the secretary on a scheduled date, that is 19 September 2008 or any time thereafter. Receive the directly proceeded to file the suit in the month of December 2008. So facts are completely different. Here also, the 16 months period was there. During the aforesaid period of 16 months. Just a minute. Page number 72 here also.
Yes.
That is the. Also, this is the case relating to specific performance of part of the contract. And
Deals with relinquishment of claim with regard
Yes.
to part.
yes, so this judgment has got nothing to do with Article 54 reduction. This with regard to part performance of a contract. And specifically, section 12(3) was considered an adjudicator. Page number 79, you worship, that is. This is with regard to will, your worship, succession. This is not a suit relating to specific performance. This is with regard to division of course, your worship, because relating to cancellation of sale and recovery of possession. So this has got nothing to do with our case, your worship.
That's all your submission? Yes.
Hey, just please, ma'am. May I just borrow the words of my little sister and draw kind attention of this honorable court towards the plaint which was filed by my learned sister before the court below, that is the trial court. My lord, there are two parts in the suit for specific performance. One is, my lord, the readiness and willingness of the plaintiff.
I think we are primarily on the issue
Yes.
that the suit was dismissed only on the ground of limitation.
I'll take valuable few minutes, my lord, referring,
Proceeds,
my
the
lord,
suit has to be sent back on
my
remand
lord.
for a decision on merits.
But I would request for few minutes more valuable moments, my lord, so that I can take my lord to the entire facts wherein the Leonard First Appellate Court has come to a conclusion of limitation. I have to just place that facts. But as per the agreement, which is at page number 49, may I just request my lord to kindly come to page number 59 once. The agreement is admitted on executed on 1990.
Yes,
Got it, my lord?
yes.
That is on 24th December 1998. Now, my lord, may I kindly come to which is the plain para number 4. It speaks like this, my lord, the argument is of the plaintiff, that it was further agreed with Rajaram that he shall hold the position of the suit line to the comes from the date from the same. According to the same physical possession. So it shows prior to how it's possible of now thereafter, my lord may kindly come to page number 4, my lord,
Yes.
para number 8 of the plane. That on 19 expired after sometimes in December 2023 and requested as the same Rajaram. But showing the still December for the scope of movement. The December. December 2023. In the and witness is showed
It's 7.
my lord. From the part of the consideration amount. Because that is also one of the specific relief act when they come before any of the honorable court. My lord, you kindly see the government. They ask about the justice but as now thereafter, my lord, para number 9, that that seems so Rajaram. So disturbance to his position in the year 2015. If the agreement of July 2016 is not taken into consideration, even then 2015 can be taken as a date when the result was announced. Now, kindly come to document side. So the land was
Yes, was the plaintiff put on notice?
my lord,
Was the plaintiff put on notice?
regarding the
Yes.
my lord, kindly see the entire no, 2015 का demarcation notice है. No, paragraph 6 of the plaint.
Yes.
The cause of action for filed suit 1990. Rajaram. And so Rajaram executed and same day. So the plaintiff that started and this action was initiated for 1992. So after that 18 years, lapse of 18 years, they have come before the trial court by filing a suit. No, my lord, no kind attention of my lord towards the cross-examination of the VW1.
At page?
I'm just coming to it, my lord. It is at page number 54, my lord.
No, I beg pardon, just a moment. I might have gone wrong somewhere. Page number 54,
It's TW1 cross.
DW1. My lord, the entire cross-examination. Uh, so that in the month of July 2016, we refused for registration. So the cause of action is for July 2016. Now, my lord, we kindly see the cross-examination suggestion from the 16th July. So they will come up with a specific performance. Not to the my lord. There is no solution to that effect, my lord. More, my lord. Again, I request this honorable court kindly come to page number 59, the sale agreement. It was the station of the sale lane, my lord. There is no dispute regarding that part. Now, my lord, may kindly come sale agreement from clause 1. The second, which is outside square meter, which is scheduled property, situated district of Andaman. Has received 10,000 as per square meter fixed 15,000. Balance amount of 5,000. Registration. Third one, the first side line, I'll request document line. Allow my lord to kindly have a look to
This is exhibit
my lord, this is
1.
exhibit 1, my lord. It's a bond paper, my lord.
Yes, yes.
Got it, my lord? Clause number 3. Approve an entire this conclusion was neither government and submission from the honorable court. So, this should be set all necessary steps to this is
Respondents are the sellers.
sellers.
The onus is on the seller.
No, the seller assured
The seller assuring the second part. The seller is the respondent.
now the comes honorable court, my lord. Judgment conviction starts from the month of December to 1998. Assuming for the moment, if 2003 there is no students because execution on the basis of statement. We said, so it was this was not
The respondent's husband received 10,000 rupees. That is the case.
condemned
Taken by the respondent's husband. Not case.
from 2016, my lord, Government servant, any government servant. That
Plaintiff is also,
is servant, he is a servant. Now, to say, submission can say, is not more than 16 at the point of time. So, second one is changing. Should-
yes.
Got it, my lord? Last para. Having perused the documents on record, it appears by 70 of the past non-application of mind concerns to the document exhibit. Kindly see uh,
Yes.
secondly, my lord,
Mutation was in 2007 at that point.
seven, my lord. And the document which the rental but also so that there will be clarification of both these, my lord, which is at the page number 68, my lord.
Yes.
This is also outside my lord, side on the seven, my lord. And some got it.
In 88.
It was allotted in so it was potential.
Said yes, it's written 14/5/2007.
My lord, my lord. Thereafter, my lord, may I put cross-examination of the plaintiff once, my lord.
Yes.
Which is at page number, my lord, 34.
Yes.
Now, my lord, may I take my lord to the cross-examination from the bottom, fourth line, my lord. It starts from after the execution. Said of Sir Rajaram did send the legal notice to him requesting to execute said child in my favor. I do to arrest some word. Said should neither signature of Rajaram signature is approved. This has created a doubt regarding the execution of that document in a valid manner. But this uh, transparency then that which was and which was not justified. I was neither tried to put trial court. Now thereafter, now respect to the said property. I will not submit to show that I am in possession of the suit land. What this question kindly come to the question report, which is also exhibited, my lord. My lord, may kindly come. Exhibit. Comes to the reference number to the different for some of land, so square somewhere only 616 and subject to or 7,022 in presence of land. Should not satisfy the provision. Kindly see if I was chalked out. So, as the said that no
Yes.
thereafter, my lord, kindly come to page 35 once, my lord.
Yes.
My lord, there was written cross-examination which my lord sister has taken care of, saying that she said that the land is 1 kilometer away from the house of the responding. It comes this way. The distance between this would is adjacent to the land of the house of the respondent. So deciding. She might have said one thing, she might have said that I'm not disputing that. But is that affected that is the question that is to be appreciated from this honorable court. But thereafter, I'm should to be asking them to execute the purpose in my favor. Since my because so the is not a mandate for this specific since the original dialogue. I need a saying. There has to be something because we mentioned that you so- so- the registration of the same date. So,
Yes.
I was telling you to second this. Job superintendent. So I take back my words and I beg pardon. I did not listen for as so she said line was not mentioned. So this schedule schedule uh schedule. When the stands up I never consider after because there is that if I purchase the land and the original tenant died, and I have anticipation the will sell it to some third person, but we trying to sell it to one third person. So in anticipation, like the suit of specific performance. I can give, sir, I can give a letter to the personal consent stating the fact and closing the sale agreement that I am in this situation of or in sale condition, kindly and objective for it. No such, PW2, it's not required because he has produced the records of right. But I just request my lord to kindly come to PW3. He was one of the testing witness because so he was the witness of the agreement.
Yes.
Just from the first line of my cross-examination, I did studies to class 8. I was studying and I was since my childhood. I received the summon from the school. Said summon. Exit was shown to the witness. Father, proceedings and the date on which I signed the documents. Whether 3 months for the execution of the sale execution of the suit land was rendered amount or any further documents. Rajaram was died in the year 2003. I do not this has been served on the other Singh. I do Suitland with Singh. The same agreement is not noticed. Registration, I can understand that it is not mandate of law, but notaries or any my submission we challenge the two schools that one first one is that we execute the once that creates a cloud of doubt regarding demarcation, then the court has to make certain steps regarding the fairness of the execution of those agreements. Then thereafter, the next page 46. From 1 to 3, sign any document. Skipping one second signature. So he was assuming for an is again in the cloud of doubt. Secondly, execution. He knows. Submission before this honorable court is that after the execution of this, these steps to change this or change this. It's neither family using. Now thereafter, my lord. Just 7, 2.
Page number 57.
57, my lord. DW2.
Yes.
Examination. In the compliance with the ascertain under the bond was shown. So it is candid clear now that the petition, neither the petition nor the defendant was in position. It was a vacant land.
Rather, it was not shown.
Assuming for a moment, my lord, suppose if it is a land adjacent to my house where I am residing and the demarcation is taken place, it is in the gentleman wants to get his right executed, might object, but disturb the proceeding of demarcation taken up by the Patwari. Now thereafter, my lord, whenever the application is submission, the authority 7 no notice have been issued to the recorded tenants as well as to the adjourned holders. Now the question fall back to the Honorable Court again is, my lord, if the plaintiff says that he is the recorded tenant of the adjacent plot holder, as per the statement in his petition,
He
no,
doesn't
he has
say
said that, my lord. He has said that. I'll just come to.
He doesn't claim to be a recorded tenant.
No. Of adjacent plot where he is residing. He said the suit property is the adjacent land to his.
He says,
Yes,
evidence says 200
my
meters
lord,
away.
my lord.
Yes.
So he has not received notice. Assuming for the adjacent unit received the notice because demarcation was conducted. Thereafter, serving spot and showed. I could say whether the suit land was better. There was some construction at the time of demarcation. It is suit line at the time of demarcation. I also cannot say even after seeing the compliance report, the suit line at the time of demarcation. So it candid clear that as far as the possession which is claimed by the plaintiff, which was handed over to the plaintiff after 3 months, is absolutely somewhere in disguise, and until now, like till the entire trial, they have not proved that part. No notice was issued to the possession of the suit land. Surveyor cannot ascertain as to who is in possession of the land. If someone applies for demarcation and the surveyor finds that someone else is in possession of the suit land, he can mention the said fact in his report. This is very critical. Suppose for a moment I apply for demarcation of my land and some third party is having possession of that land, then it has to be mentioned in the demarcation report that somebody else is in possession. We cannot demarcate the land unless and until the dispute is resolved between the parties. So it is crystal clear that even the possession of the suit land by this version of the Patwari. And it is the cross examination on behalf of the plaintiff because he is the defense witness, defendant witness. Now thereafter, my lord, may I just draw kind attention of my lord. Now, my lord, may kindly come to page number 140, the judgment of first appellate court. Page 140, para number 4.27.
Yes.
In the light of other legal principles, the solemn decision of court and high court, when the judgment passed by the trial court is scrutinized carefully, it is found that when the trial court decided issue number 1 has to be maintainable, respondent plaintiff, and the core issue number 2, additional issue 1 as to whether the suit is barred by limitations to be seen. If decided by the trial court correctly on the basis of the record, provisions of law issued as to the entitlement to that is issue number 5, is also vital from the circumstance of this case. So far as the finding on the issue number 3 with regard to agreement in question is concerned, it appears that Exhibit 1, whereupon signature of Pritam Singh has been identified as Exhibit 1 by 1, and that of PWC as Exhibit 1 by 2, signature of Rajaram as Exhibit 1 by 3. This agreement is this case, and in order to resolve the controversy issues, the recital of this agreement needs to be referred. Contains or purchase and clause 2 contains the 10,000 has been received as a part sale consideration in respect to 200 square meter of land out of 15,000, and survey number 506 has been mentioned in clause 1(3) of the contained that first part. Said line that is outside to second party within 3 months. Clause 4 contains that the seller assures the second party to purchaser to take all necessary steps to make it registered in favor of the purchaser. Questions have correctly because we now trial this issue consideration shows respondent childhood and 24 7 consideration of rupees 50,000. The respondent to the is clear that the possession of the suit property was handed by Mrs. Rajaram with the execution of a the respondent right, saying registered in respect to suit land, Rajaram told him that he should not registration and sale agreement is sufficient to protect his right. He further Rajaram 2000, he said Rajaram told that the plaintiff that in order to get the sale deed registered in respect to the suit land sale permission is necessary. He also told the plaintiff that he has applied for sale permission and once such permission is granted, he will register the sale deed. So in the light of the schedule specifically suit for specific contract as 3 years and the limitation start so now is not specifically mentioned that when I refuse. But my lord may kindly appreciate para 11 of the plain says, my lord, that the cause of action started from the year 1998 and on each and every date it continues. So it is the provision if this cause of action continues from December 1998, then either 3 years of Rajaram, maybe in the year 2003, from there to 2007 or 2006.
Yes.
Thereafter, my lord may kindly see page number 142, last para 4.32. The plaintiff of the respondent contains vague arguments with regard to the date of performance in as much as that it seems to be a clever drafting to somehow make out a case which is otherwise barred by limitation. Because of the reason that as per 6 of para 6 of the plaint, it was in the year 2000 when the performance of the contract dated 24/12/1998 was refused by these Rajaram, but the respondent plaintiff somehow tried to put the Rajaram that he ever to register his sale in this para. This in para 7 and 8 of the also the respondent plaintiff specific on and month is also not mentioned in the governments in the plaint. From 2003 December 16, there is nothing to say in the plaint that within this 11 years, with greatest respect to this honorable court, the has put any endeavor from any corner to approach the respondents in any manner to get the shaded registered in his favor. Now thereafter, my lord, is explanation of limitation in para 4.2, 4.32, my lord.
Yes.
Now, my lord, may kindly come to page number 145, my lord. 4.35.
Yes.
Finding of the that it was for different specific problem refused is not correct. Admittedly, my lord, that the defendant refused, but then the trial court said that it was refused by the defendant, so they have to prove it. It's a case of a plaintiff. Because then thereafter, my lord, kindly come to para 4.36.
Yes.
In an agreement to sell of property, can be avoided considering conduct and circumstance of the case under which contract was entered, circumstance making it inequitable and put specific performance in this case. The respondent plaintiff of the sale agreement. This is really something which is very suspicious, my lord, on the face of the document, because every document is a primary evidence as per the Evidence Act. And court has to consider those evidence on the face of its record, my lord. But when there appears to be some manipulation or something which is tried to be raised.
Need to be dealt with by the first appellate court.
My lord,
First appellate court has not gone into merits at all.
my lord.
It was turned down only on the ground of limitation.
But my lord may kindly appreciate the limitation part which has been appraised by the first appellate court. If my lord may kindly scrutinize the plaint and the agreement, then my lord, the limitation part which was taken by the first appellate court, I will with my greatest of respect say that the first appellate court was right enough and correct enough to say that the limitation runs from the month of December 1998 as per their pleadings. And the court was absolutely passing alternate remedy to the plaintiff. And my lord, on the behest of that particular judgment, we have deposited the money for the trial court also, which was directed to do so. Now may I just take my lord to my judgments? Hi, Baba.
Issues number 2 and additional issues number 1 and 5 are set aside. What were the other issues?
I'll just come to it, my lord. Issue number 2 is, my lord, whether the suit is barred by the law of limitation. It is at page number 96, my lord, of the Learned Trial Court judgment. And additional issues number 1 and 1 is whether the suit filed by the plaintiff barred by limitation, whether the plaintiff is entitled to decree as paid for. These are the 3 issues which was
What is issue number 5?
5 is whether the plaintiff is entitled to decree as paid for specific performance. So this was actually judgment was in favor of the plaintiff regarding all this in the trial court. So that has been set aside, my lord.
Yes, there were several other issues. Only 2 and additional issue 1 and 5 are set aside.
My lord.
But the other issues were also decided upon by the trial court. 1, 3, 4, 5, 6. They stand.
तो कुछ डिस्कस नहीं किया तो डिस्कस नहीं किया नहीं किया नहीं किया नहीं किया नहीं किया additional issues 1 and 2 The
first appellate court has not touched upon the other issues at all.
My lord.
So they remain. So if this court decides that the limitation part is overcome by the petition, by the appellant, the other issues are already there in favor of the petition.
Let me kindly appreciate one thing, my lord, subject to my little knowledge. As there are 8 issues.
Yes.
2 additional issues and 6
set aside.
Set aside. My lord, if the suit is decided on the point of limitation, the other issues goes, my lord. Because when the suit is barred by the law of limitation, the other.
This court decides that the suit is not barred by limitation, the merits revive and the other issues remain.
My lord.
They have not been challenged by you.
My lord.
Because other issues are in favor of the plaintiff, the appellant hearing.
But as the first appellate court has taken up the issues number 1, 2 and 5, then my lord, in that case, in sense, I may be wrong, my lord, but
the hearing, so I think it will be safe for me to say that you ought to have come back with a cross appeal. The other issues are against you in favor of the plaintiff. And if this court decides on limitation in favor of the appellant, other issues remain. So there is no question of sending it back on remand on merits. Merits are already on record.
my lord.
Right. You can join issue if you want. I mean,
My-
it's just a suggestion from my part.
My lord. I'll come up with my appeal, my lord, in that
Yes?
case. I'll come up with my appeal then, for other issues,
Not at this stage. Let me dispose this off.
my lord,
You'll have your chance. You'll have your, in accordance with law, you can do that.
my lord. Can I place my
If
judgment?
limitation goes, everything goes.
But my lord, as far as the facts on record, the pleadings of the plaintiff in the plaint, which categorically make it clear, my lord, in 2-3 paras that there are, I can
Yes,
say,
limitation, I'll deal with.
yes,
I'll deal with the limitation part.
my lord,
But initially, I was under the impression that if limitation is in favor of the appellant,
my lord,
I need to send it back on remand for deciding on merits.
my lord.
But I find here that only 3 issues on limitation were set aside. The other issues are all on merits of the case. They
I think the first appellate court has not decided those issues in the entire judgment.
since they are not set aside, they remain.
It has not been set aside, but there has to be some thing on record to say that, my lord, these issues stand by, but on the point of limitation,
Since
the appeal is allowed.
that be done.
Because
Once the
Because the
appellate court
first appellate
holds-
court decides the entire issue, it's not only on the limitation, my lord. Because argument was done full-fledgedly on on all the corners of the issue.
Yes, the appellate
But
court
the
has
appellate court
considered.
had come to a conclusion regarding the issues of limitation, and then the issues number 2, 5, and
Consider the entire facts on merits.
Submit one thing, Eviction. The learned first appellate court ordered for refund of money because the learned first appellate court found that the agreement is correct. Otherwise, there is no question of refund of money. That is the reason why I'm saying that the issues have been decided, other issues have been decided in my favor. Because whatever
I'll
points have been
take-
raised by the other side relating to the agreement in question, that agreement, that particular agreement is considered to be a genuine agreement.
The
by-
matter was dealt with on merits by the first appellate court.
my lord,
All the submissions were made, they were dealt with.
Yes.
Finally, the first appellate court came to a conclusion that
regarding limitation,
it is barred by limitation.
limitation,
That's why those 3 issues were against the
Against them.
plaintiff.
plaintiff.
These issues have to be in my favor, otherwise there cannot be the refund of money. The genuinity of the agreement is
Well,
accepted.
I'll not comment on that.
You know,
I'll
saying
not
that-
comment on that. Yes.
So
Because
may I
that
just,
can be 2 ways. Well, either a refund or a specific contract.
My lord.
Unless and until the agreement is found to be correct or genuine, the court cannot even direct for refund.
No, because the amount is admitted. They
You know,
say that it was
it's
a
the loan amount.
So in any event, there has to be either a refund or a specific performance.
There is a discussion.
Yes,
Refund
yes.
Also discussion is
No,
there.
that's why I say that it was dealt with on merits.
Yes,
Only
yes.
finally the court found that it is barred by limitation. It was set aside on those 3 counts.
Yes,
So
yes.
if that
My lord.
was in the favor of the appellant, the remaining part is revived automatically. That is what I say.
My lord.
And I think you'll agree with me. Anything else?
My lord, my paper book, this spiral binding, my judgment
Yes,
is there.
yes.
May I just take my lord to that?
Yes.
Salutation, first page, my lord, from the bottom. 10th line from the bottom, first page, salutation, my lord. The
Next page.
salutation, first para,
Yes,
my lord.
yes.
From the bottom 10th line, my lord, starts, court is not bound to grant specific performance. Got it, my lord?
Yes.
Court is not bound to grant specific performance merely because it is lawful to do so. Motive behind litigation should also enter into judicial verdict. Court should take care to see that it is not used as an instrument of oppressing to have an unfair advantage to plaintiff. High Court has failed to consider motive with which Varghese instituted suit. It was instituted because Kuruvilla could not get a state and Matthew was not prepared to part with it. Sheet anchor of the suit by Varghese agreement of sale so and so so and so. Since Chettiar has waived his right, thereunder Varghese as an assignee could not get a better right to enforce. That agreement is therefore not entitled for degree of specific performance. Now, my lord,
It's a different aspect, issue.
but my lord, the court has discussed in para 5th, para number 5. I'll just give the important paras, my lord, may kindly
Yes.
take a note of it. 5th para, page number 2, my lord, bottom. Then para number 13 and 14.
Yes.
Now thereafter, next judgment, page number 6, my lord.
Yes.
It is on specific relief section 20 subclause 2, my lord. Breach of agreement, but when court will not exercise discretion to grant specific relief. The jurisdiction to decree specific relief is discretionary and the court can consider various circumstances to decide whether such relief is to be granted. Lawful to grant specific relief, the court will grant the order for specific relief, but this discretion shall not exercise an arbitrary. Certain circumstances have been mentioned in section subclause 2. As to what circumstance the court shall exercise such discretion from the time of the contract, it's an unfair exercise the discretion in favor of the debtor. So also specific sheet which will be foreseen at the time of agreement. If it is any specific, then also the court will desist from granting degree to this specific relief. Now this is at para number 7, 8, and then my lord 15, 16 and 17.
Yes.
Sorry, my lord, 15, 16 and 17.
16. Yes.
This is the third judgment that page number 12, my lord. It is on the second limb of section 54. When date is fixed or definitely for or suggestive date. In this case, the case in hand before my lord. My lord, kindly see when the date from the year 1988 and all the subsequent dates.
Agreement doesn't have a definite order
Madam.
subsequent date.
I bow down for that, my lord, but on the same time, it is always the my lord that the buyer must be aware of every negative and positive aspect of a purchase made or a agreement entered into. There is no date from 24/12/1998 and on the all subsequent dates, the cause of action run subsequently.
But this
So-
judgment is otherwise.
My
This judgment is not applicable.
Now thereafter, my lord,
16.
16. In this, my lord, may kindly come to para number 53 and 54, my lord. 53, 54, my lord,
Yes.
and para number 19, Adi para.
23, 25,
19, 19, my lord.
and 53, 54.
Ji, my lord.
Yes. Yes.
It says about section 20, specific provisions of contract code is bound to grant specific provisions because it is lawful to do so. Jurisdiction to decree specific provisions is discretionary.
This is a
Discretion.
repetition of the earlier judgment. Same thing was there.
This one is the recent one of the 17. That was the old one, my lord, and the para is 10 to 13. 8. First is para 8, then 10 to 13. Thereafter, my lord, page number 46. It speaks about revision of Article 54. Para is 20, 21, 29 and 30, my lord.
20, 21.
29 and 30, my lord.
Yes.
Thereafter, my lord, may kindly come to page number 54, my lord.
Yes.
In this para number 12, 13, 14 and 16, my lord.
Yes.
Thereafter, my lord, may kindly come to 61, my lord.
Yes.
Here, my lord, the alternate relief was granted in the suit of specific performance. Relevant para is, my lord, may I take my lord to para number 27, 28, 29. Then 31, 32, my lord. Then para number 34, 36 and 40, my lord. Next judgment is, skip this judgment. Skip this judgment. I'll come to the last judgment at 79.
Yes.
Here, my lord, kindly see how it is to be computed. That has been mentioned in this suit, in this judgment of the criminal, and the relevant para is, just a moment, my lord, I'll give the para. No, just a moment, my lord, I beg pardon for delay. Para number 31, 30. So my humble submission is, my lord, the judgment passed by the appellate court, first appellate court rather, is correct, and I pray to understand.
Yes. Short points. You've deposited the amount you said in terms of.
Yes, my lord, yes, my lord, yes, we have done that.
But we have not taken it in action.
No, they have not taken, my sister
Taken.
clients had not taken it, but we have deposited the same.
Yes.
Your Lordship, the first thing is that relating to the mutation, because that is a point raised, it was done in 2007. Your Lordship, I kindly see DW1 cross-examination. I'll just show it, Your Lordship, and thereafter. Page number 54. The line in between, Your Lordship, the mutation of the suit property was then.
Oh, okay.
Page 54.
Cross examination.
Yes.
The mutation of the suit property was done in our name in the year 2015. This is by DW.
The respondent.
The risk. This is.
Yes.
10th paragraph. So, you know, so what my contention is that mutation is not a public thing which is done in public. There is,
When it is oral evidence versus documentary evidence.
of course, documentary will play. But what I am submitting is that by saying so, this information is given that I came to know knowledge about the mutation only in 2015. I am saying that because when I am cross-examining her, that when the mutation took place, she says 2015. So the plaintiff was made to believe that till such time, up to 2015-16, the mutation did not take place. Because that is the averment made by me. What is my averment here? That for about 2 years, paragraph 9, that for about 2 years, the legal heirs of Rajaram did not take any steps on the ground that unless land is mutated in their name, they cannot register the sale. What is a written statement? It is written. And this is paragraph 9.
You are again on facts, madam.
No, I'm just referring, Your Lordship, just to show that, because in order to deal with that, Your Lordship has to look into this thing, that for that reason only.
Page number 11. Page number 11.
Yes, just a denial. Nowhere it is stated that it was already done in 2007, so there was no requirement to mention about that mutation. So they have been saying that mutation, once mutation is done, we will register it. That is my case. Now, Your Lordship, the second thing is that relating to NCFIR, because when they started disturbing my possession, I lodged a complaint. That about that particular complaint, DW1 has admitted.
Yes,
in the
that is
last
admitted.
paragraph.
Yes,
She has
that is
admitted. So my contention is that, Your Lordship, my basic cause of action, the date of refusal is the date when I have lodged the complaint. Just that. Your Lordship, the first appellate court judgment, Your Lordship. Your Lordship, the amount of 10,000 was refunded under considering section 20 of the specific relief act. This is important, Your Lordship. This goes to show that the agreement, so far as the existence of the agreement is concerned, and all these the issues which have been decided in my favor, Your Lordship, that was also considered by the learned first appellate court to decide the issue relating to refund of money. It was not the loan. Otherwise, there might have been a definite finding by the first appellate court that it may be by way of a loan or it may be a consideration. That amount has to be refunded. That reasoning or finding ought to have been there. But other issues have been decided in my favor, not set aside. So considering those issues which have not been set aside, and it was in my favor, this 10,000 rupees was directed to be refunded. That is my contention, Your Lordship, with regard to this aspect. You see, in between 4.37, Your Lordship, in between it is written. But at the same time, consider principles governing the provision of specific relief act, more specifically, provision of section 20 of the specific relief act to award the compensation. So that has been applied.
Yes.
So my submission is that, Your Lordship, I have needed properly, Your Lordship, when all those things have happened, and just one thing, Your Lordship, may or may not be so relevant, but Your Lordship, page number 35. I don't know, because that has not been corrected, so we should take it as it is. Your Lordship, page number 35.
Yes.
Just 14th line, Your Lordship, from top. It is not a fact that I never approach the defendants to execute the same deed in my favor. That means I approached the defendants for execution of the same
That's
deed.
a denial. The cause of action part also in your plaint, it says from the date of deed.
Your Lordship, that cause of action is a bundle of facts. And we used to write the pleadings are like that, Your Lordship, the cause of action. This is not the cause of action with regard to the date of filing of the suit. That is the entire thing which has been started. It
That's
started
right.
in 1998, then it went on, and the refusal. I have not stated, Your Lordship, kindly see, the complete, it has not been read. It was not read completely. The cause of action for filing.
No, then it continues, that you've stated.
Not only that.
I've read that.
Not only that, then, and when the plaintiff requested the defendants to execute the same deed, and in July.
Yes, 2016 is also there, yes.
When the
But it
defendant.
I've seen that, man.
starts from 98, that's what you say.
That is, Your
I'll
Lordship,
deal with it. I'll deal.
leading, Your Lordship, knows, Your Lordship, that it goes here and there, but we have to see,
Alright.
so far as.
Leading is the foundation of a civil suit.
Cause of action and limitation, these are two different things, we should not mix it. Limitation point will start, because as per the specific relief act, I'm arguing the law point, Your Lordship. Specific relief act, the court says, the law says, from the date of refusal, we have to count the limitation. It is not that the cause of action. Cause of action are bundle of facts decided by the Honorable Supreme Court. Entire pleading, what and all has happened in the case, all are cause of action. But so far as limitation is concerned, it is from the date of refusal, we have to count.
That's
If
right.
Article 54, second limb is applied. This is my submission.
I'll reserve this.
Yes.
Argument concluded, judgment reserved.
हम लोग का है इतना काम करेंगे रेगुलर बुक रखी उन्हें भी छोड़ दूंगी इतना कर सकते
Yes, next matter.
I am for the state CBI, my lord. My brother.
Yes, there are 8 matters, I think.
All the matters on the list.
Nature, yes.
matter. It may fix on Monday or Tuesday.
No, today. No Monday, Tuesday.
Don't
Don't shift all the matters to next
So
week.
Tabriz is appearing in the matter is not well, it seems. He has also called me personally, so
What is the
only,
issue about?
my lord, actually what had happened, my lord, there was a FIR chalked out in the year 2018. And then during the course of investigation, FIR was added. This set of accused persons. But they came up with the challenge that there can't be a different number of FIRs. But our contention is that during the course of investigation, we got the different mode of payment made through this gentleman from the contractor and to this
So that could have, the same petitioner, the same accused in all the cases.
same accused. But different persons were from different transferred.
Come up with charge sheets, supplementary charge sheets, why different FIR?
The investigation is going on. I think the charge sheet has not come up. Again, file again.
Even if there are different issues, can be clubbed.
Yes, instead of quashing, that is what I suggested to my brother. It can be clubbed together.
Quashing of the subsequent
Yes,
FIRs.
yes. But in the case of prevention of corruption and quashing is something which is out of imagination.
Down only on the ground that there is an
Different
early,
FIR, my lord.
right? They have to be clubbed
It
together.
has to be clubbed together. I will not stand in the way if it is clubbed together and taken up
Very
the charge
useful.
together.
Come back on
My lord, my lord.
Monday. Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on Monday is 4th. All these 8 matters together, right? Oh, till 18. How many matters can be taken up on Monday? Please tell me. That's the last week of the circuit. You are for the petitioner. What is the issue about?
My property has been carved out to a private person without any inquiry. Twice I approached the school, twice orders of the authority to set aside. Direction was given to the authority to go to inquiry. Identity order again has been passed. They are challenging the person.
Have you served the private respondent? Oh, and the authority?
What is the loss?
You are appearing? You want it on Monday? Tuesday?
And
Let it be on Monday. Let us not waste a day. Learned counsel for the private respondent seeks accommodation. Let the matter appear under the same heading on 4th August.
Yes.
Very well.
What they are saying like that.
But in this matter, there was a direction for exchange of affidavits. That is over. That is done.
I did not get the reply. Your Worship.
Very well done.
Decided the issue.
And they preferred an appeal against that same issue.
They are saying next week you have to let it be on Tuesday.
No, if there's an appeal, well, let it appear on Wednesday. Let us see whether the position of the appeal.
Consent for the they have put an appeal against the consent, but appeal was dismissed finally. Review was also again appeal has been done against the consent order.
Oh, appeal was dismissed earlier.
Yes, appeal was dismissed on the ground. Just a minute. Because it was a consent order, so appeal was dismissed and the court has said that you have to have a review application. Liberty was given to them. Review was filed.
Review was dismissed.
Again, they are filing.
Yes, since it is a consent order, appeal court has restrained from getting into the merits because it's a
Consent order. No, again, they are filing.
My lord, I am appearing for the, my lord,
Is there a ground of fraud or misrepresentation?
No, nothing.
That's the
my
ground.
lord, I am appearing for the respondent in this, I am appearing, my lord, in this matter.
Yes.
Now, my lord, what has happened is that a similar matter, my lord, a review was because what had happened is on the first date, there was a consent order. So, my lord, those grounds which were not taken because it was a consent order were taken in a review petition. The review petition was dismissed. Against both the orders, an appeal is preferred. Now, in this case, it is different because in this case, my lord, there is no consent. So, therefore, my lord, we have taken the stand, we have taken the defenses in the affidavit. But, my lord, since that in the course of review jurisdiction is different, my lord, because it's limited scope. So, even if we have raised points on merits, those would only be looked at from within the prism of review jurisdiction. So my lord, but at the same time, those findings are there. So my lord, which is why we were requesting that, my lord, if this can be adjourned, because that appeal, if it is, if that appeal is, for instance, it may be to the other side's benefit also, my lord, because if that appeal is dismissed on merits, then my lord, that this will also have to follow, my lord. You know, the single and honorable single judge who will be hearing this matter would definitely consider the findings of the division bench. So
On your lordship, it is not listed. We don't know what is the mat number.
it has been filed, my lord. It will come up, my lord. Let this be adjourned to the next circuit, my lord.
But it is not listed.
No, let it be, my lord, as a last opportunity. My lord may say that we will.
Let it
we will
appear
give
on
it.
Tuesday, let us
Yes.
see.
Let us see.
Wednesday.
Why Wednesday? Let us be on Tuesday.
So he'll have to process it, my lord, for listing, my lord. So
You say that it has been filed already.
it has been filed long time back, my lord.
Further,
It has been filed.
if it is filed, it will
The
come in.
difficulty with the panel also, my lord. Let it come in the next circuit, my lord. They have also consented to adjournments in the past.
What is this? That means appeal has not been filed.
No, it has been filed. I'm saying so. Why does it mean it has not been filed?
Give a copy of the appeal. man. Don't
You
you-
give
When I'm
the
saying it has been filed, it has been filed. I'm not saying it has been already filed.
before this on.
Let it
Put it
pass
in the
over,
listed-
man.
All right, that's fine. My lord may have it whenever, my lord. We'll get the appeal listed. No difficulty.
And for that, if the appeal is filed, I'll send it to the next circuit. I'll keep. it.
Yes, my lord. Appeal has been filed. There is no.
Yes, madam.
Please give her the
Yes,
number.
yes, yes.
Yes.
Rakesh will give the number.
The matter is adjourned for the day. Please come in. Next.
Item number
1 and 28, same order, right?
Yes, sir.
20 and 28, not 20. 20 and 20. Please.
21, I am appealing for the
Item
response.
number 21, WPA 230/24, 22, 23, 24.
Now, out of 5 matters, one has been disposed of. On the ground of clarity of reasoning, these 4 matters can also be disposed of. It
Who is appearing for the?
I am appealing for the respondent, my lord.
orders by single judge by the division bench.
What is the issue?
So what has happened? Till now, the property is recorded in the name of my deceased father. But in the remark column in the land record, it is shown as if it is deserted. That remark has been challenged. That came up for consideration in the WP 22/26 of 2024. 2-3 judgments were cited. The writ court said, Lordship, to go back to the authority. And my specific point was, Lordship, it would be an idle formality when already decision has been taken. Post decisional hearing would be an idle formality. The writ court even then said it would go before the authority. Settle findings have been recorded. Then I approached before the division bench. Lordship, my possession possession was protected, and the order of the single judge was modified to some extent. I have filed both the orders, please.
Why separate applications? There are separate
They are
properties.
brothers and sisters, Lordship. They have instructed me to file it individual because they have their.
Property is same,
No, they have their specific right over the land property.
only one
Individual
property.
right.
All the brothers are individually filed.
I can show the material.
There was a direction to treat the writ petition as a
By the
representation.
honorable single judge, then that was modified by the honorable division bench. The writ petition cannot be treated as a representation. I have been given liberty to make a comprehensive representation. Within certain time limits, my possession was protected, my lord.
It's primarily for correction of the records, right?
Yes.
To remove that observation, that recording.
Observation, because they say, my lordship, that the property has been resumed. Under the special statute which is prevailing in this island, there is no provision to resume the land. As of now, this record stands in the name of my deceased father. By virtue of his death, my lordship, we inherited it. But in the remark column, that has been shown that this property has been resumed as deserted. This was taken care of by both the report as.
So let me dispose of these matters on the same line.
My lord, the only thing is that they may file a representative within a time frame. I don't know when they will file representative.
Suppose these petitions, my lord, can fix a time limit.
Time limit.
Suppose these petitions are concerned 21, 22, 20, 24.
Here it was 4 weeks from date.
Yes, I have already
So
made.
let it be 4 weeks from
Yes.
date again.
Yes.
With some protection as accorded by the division bench, as regard my position.
I'll repeat the order.
Well, I'm reading, I'm reading.
Obey the law.
Heard learned counsels for the parties.
Yeah, refer must be included, remark.
No, I'll see this, the earlier orders, and I'll make an observation. Five cases filed, right?
It's, one is disposal,
No.
these are the four.
5 separate cases have been filed by the petitioners herein and another who are siblings. All of them are
Yes,
siblings,
mother.
no? Who are siblings. Praying for a writ of mandamus. Quashing / setting aside / cancelling the impugned recording of resumption in the land records of the subject land as maintained in the statutory record by the third respondent. Learned counsel for the petitioners submits that though the record submits that the land, the property in question has been recorded in the record of rights in the name of their predecessor in interest, right? The predecessor in interest of the petitioners. On rectification of such records, it was recorded that within inverted comma, the holding has been resumed vide order dated 14th April 1980 of the DCFCC recorded in the sheet 05 corresponding revenue case number 2469 corresponding to QRC number 54/76 within bracket Tehsildar Mayabandar, comma, in charge. Stop. One of the heirs of the original tenant filed a writ petition before this court, being WPA 226 of 2024. And upon consideration of the submission made on behalf of the parties as well as material on record, comma, a coordinate bench of this court directed that the respondent authorities should treat the writ petition as a representation and hear the matter upon service of notice to the petitioner therein and pass a reasoned order. The said order was assailed by the petitioner in the writ petition before an honorable division bench of this court. Stop. By an order passed on March 10, 2025, in MAT 19 of 2025, comma, the order of the single judge was modified and the petitioner therein was directed to file a representation with all the documents in support of his claim over the land in dispute within 4 weeks from date. Stop. The Tehsildar was directed to dispose of the representation by a reasoned order within 6 weeks thereof, or 6 months, sorry, not weeks, 6 months thereof, upon granting reasonable opportunity of hearing to the writ petitioner without being influenced by the observations made in the said order. The possession of the writ petitioner was protected by an order, by a direction not to disturb his possession till a decision was taken by the Tehsildar, Mayabandar in accordance with law, provided the representation was filed within 4 weeks from date. Paragraph. In view of the similar nature of the present proceedings, proceedings and identical prayers made herein by the other heirs of the original tenant, this court is inclined to hold that the petitioners herein be directed to submit representations before the concerned authority in conformity with the directions of the Honorable Division Bench. Paragraph. In view of the above, the petitioners herein are directed to submit a comprehensive representation before the respondent authority along with documents in support of their respective contentions within 4 weeks.
No.
Within 4 weeks from date, stop. The authority / Tehsildar is directed to consider and dispose of the representations upon granting reasonable opportunity of hearing to all concerned, including the petitioners, within 6 months from the date of receipt thereof. It's not necessary to record influence by, because I have not made any observation at all. Stop. In the meantime, the possession of the petitioner shall not be disturbed till, I shall say, till a month after decision is taken. Because otherwise the next day
My lord,
it happens. It happens. Will not be disturbed till 1 month after the decision is taken. Shall not be disturbed till a period of a month from the date of the decision. The writ petitions are accordingly disposed of. As in certified.
Letter number 25, WPS 00924 with letter number 26.
Lordship, my senior is appearing for the petition. I pray that this be not today, Lordship. Lordship, because in item number 26, one of the petitioner has filed an application for withdrawal.
For withdrawal.
For withdrawal.
But I served a copy of the can today, and
Tomorrow,
it is not listed, I suppose.
It has been filed just today.
can is not listed.
My lord, no difficulty, my lord. Your lord.
Uh,
Let me fix on Monday, Your Lordship.
yeah, item 25, can 1 is listed.
No, no,
Your
ma-
Lordship, that-
they filed
that
can in
has been
item
filed
20
Filed in item number 26.
26.
26.
Oh, what is the can in 25?
That,
There's a can in 25 also.
I don't know.
What is
I have
that?
a copy of that can.
You have a copy of?
No,
both
no,
of them?
I have one can that is filed in can in item number 26, WP 314.
You will come back tomorrow?
Your Lordship, let this be fixed. on Monday.
Let it be tomorrow because withdrawal has to be done.
Yes, yes.
So she has to join the service. She has given an interview. She is.
So tomorrow.
Yes,
tomorrow.
tomorrow.
On
But
prayer
this
of
is
petition-
can is pertaining to, I suppose, interim order.
Interim order.
Yes, yes.
That is-
On prayer of
that is
petitioners.
legal.
Comma, the matter is
Still
adjourned for the
disposed of.
day.
I'll argue. and-
That is infectious,
I'll
I
finish.
Adjourned for the day.
Yes.
my lord.
Number 27.
Your Lordship, I am for the petition, ready matter, Your Lordship, it can be.
My lord, they have not served reply, my lord, whether they intend to file reply in the one.
Already
Sir,
served, sir.
Kal diya. Yesterday they served, my lord. Yesterday,
It
yesterday.
was served yesterday, my lord. Let it come in the next week, my lord. I have not been able to because it served only yesterday.
Monday, Your Lordship.
Not everything cannot.
Very
be-
short matter it is,
Short matter.
not a big one.
Very good. Learned counsel for the respondent seeks accommodation. Let the matter appear at the same meeting on 4th.
Your Lordship.
My lord.
Okay.
Item number 29. WP 368 of 24 with item number 30.
I'm for the respondent, madam.
Petitioner?
Yes, I.
Yes. Yes.
Encroaches in this island.
No private opposite party, right?
No. The encroaches in this island have certain rights recognized. It's not that they have occupied a government table land, they can be evicted easily. But the petitioners wherein are the encroachers of a government table. There was a threat of destruction. The Tahsildar ought to have set the appropriate proceeding in motion. The appropriate proceeding in this island would be regulation 202 of 1966 regulations. Once an order is passed under regulation 202, the person suffering eviction order has a right to establish his right in a civil case. Not initially, I made a representation and nothing was done. I approached this court. But this court passed an order. I'll just draw on to that order first. Or can find that order at page 34 and 35 of the present petition. It's annexure P5.
Thirty. 433 starts, this is the order of the Assistant Commissioner. A single bench order?
Yes.
I think it's 31. 5th February order.
On the other file.
Oh.
Yes, it's 31.
Yes.
Not may I place your. The petitioners prays for a restraint on the respondent's authority not to evict the petitioners from the land without the process of law. Although the petitioner does not disclose any documents articulating such process or otherwise, the counsel for the petitioner submits that the Tahsildar dignitary is bent on evicting the petitioner without giving any opportunity to the petitioner to prove his right to remain on the land in question. The learned counsel appearing for the respondent submits
that the land in questions belong to government revenue department and the petitioner has illegally encroached on the said land. It however appears from the record that the petitioner has made a representation to the Assistant Commissioner Diglipur on 14th November 2022, praying for intervention of the Assistant Commissioners with regard to the government revenue land which the petitioner has occupied for more than 35 years. Admittedly, the Assistant Commissioner, respond number 3, has not responded to the representation. Considering the balance of equity, this court is of the view that the respondent number 3 should first respond to the representation before any action of eviction is taken against the petitioner. WPA number is accordingly disposed of with the direction on the respondent number 3 to consider and dispose of the representation of the petitioner within 8 weeks from today. The respondents authority shall not take any action against the petitioner in any form of eviction or any other penal measures till 3 weeks from the date the reason order is communicated to the petitioner. The respondent number 3 shall give an opportunity of hearing to the petitioners before arriving at the reason decision. Now, based on this direction of this honorable court, the interim order at page 33 came to be passed. But I just draw a loss to the penultimate paragraph at 38, the adjudication made 38 from the submissions following inference emerges.
Yes.
Subject land claim for encroachment for livelihood purpose by the petitioners in village common land, government revenue land will form a oath unoccupied government land other than those set apart for listed or available for disposal under non form by Dilio, upset Nala, no visible signs of old parental occupation of the subject land by the petitioner is seen from the reports and photos on record. There is no documentary evidence of such occupation by the petitioners for 30 years as claimed by them. The petitioners are unable to prove any unlawful action or initiative for such action on the part of the revenue officers, especially the respondent number 4, the procedural Diglipur. Under such circumstances, it is concluded that the claims and allegations of the petitioners in the representation dated 14/11/2023 are unproven and therefore not tenable. Not to arrive in decision, Lord would see right from page 33, certain adverse reports were filed. Lord, the coordinate bench, while directing the authority to take a decision by applying the principle of natural justice, it obviously means, Lordship.
You were heard by the authority?
Lordship, hearing was done. But Lordship, if an adverse material is collected behind my back and I'm not given an opportunity to deal with it, it's a facet of principle of natural justice.
Did you place your documents in support of your contention?
I have argued before the court what are the documents I am having and which form part of the writ petition. We treated the as my documents. Everything was placed. They do admit, Lordship, that I'm in possession. In one hand, they say that, Lordship, it's a nala. I will show the classification of land, the government revenue land. But on the other hand, they say, Lordship, it's occupied by the petitioners. Adverse reports were called for. Not what the authorities does, Lordship, in every cases, they call for a report. In course of hearing, either they should have allowed me to have an inspection. That was not done. If the documents is voluminous, the reports are contained of only 1 page, Lordship. They should have given me a copy so that I could have contributed those reports. And after dealing with those reports, the decision could have been taken. This is my first ground of attack so far as impugn order is concerned. If impugn order is concerned, Lordship, it's without principle of natural justice, this has been done. I've taken this specific ground in my writ petition. I'll just show that the ground which here I have taken. When the report says, Lordship, opportunity of hearing, they simply what they do, Lordship, they simply issue a notice, call my client, hearing done, passes an order. But while passing an order, they rely upon the adverse material. In course of hearing, Lordship, they must disclose to us that these are the reports we have called for. You want to say anything as regards that? Or if the reports are so voluminous, I have a right to the inspection. Even these two things were not done. I'll just show the first ground which I have raised. If allowed this, I could persuade my lord on the first ground, Lordship, that the impugn order is constitutional. So, ground your kindly see, Lordship, impugn has been passed in violation of principle of natural justice. Then, my lord. Secondly, my lord, sees the impute order. Show. Only see page 20 of the petition. It's a government revenue department plan, my lord. If that be the case, my lordship, the Tahsildar is the proper authority, my lordship. Lord would looks into regulation 202. It's very clear. But these are the matter to be gone into a suit. Lord would see if an order is passed under 202. 202, 7 and 8 gives an encroacher a right to establish his right in a civil court. If a notice is given notifying the intention to file a suit, the order of the eviction would be stayed.
Let
And
me
it-
see that
Mala, I have to
regulation.
finally come to regulation 202. I would find at page 40 of the first
Yes,
regulation.
yes.
Not any person who unauthorizedly takes or remain in possession of any unoccupied land or abadi land may be summarily ejected by the order of Tahsildar, and any crops which may be standing on the land, and any building or other works which may he have constructed thereon, if not removed by him within such time as the Tahsildar may fix, shall be liable for forfeiture. Any property forfeited in the subsection 1 shall be disposed of in such manner as the Tahsildar may direct, and the cost of removal of the crop, building or other works, and all works necessary to restore the land to its original condition shall be recovered from such persons as an arrears of land revenue. Such persons, subject to the provisions of subsection 5, also is liable at the discretion of Tahsildar to pay a fine which may extend to 250 rupees. The Tahsildar may apply the whole or any part of the fine imposed, but kindly straight away come to not subsection 7 and 8. No order made under subsection 1 shall prevent any person from establishing his right in a civil court. If notice of intention to institute a suit is delivered to Tahsildar, he shall desist from carrying out his order under subsection 1 for a period of 3 months. And if such suit is filed within such period, he shall stay his proceeding pending the decision of the suit.
So firstly, this order was not by the Tahsildar.
Not by the Tahsildar, it was passed by officer in hierarchy and assistant commissioner above the Tahsildar.
Above the Tahsildar.
Above the Tahsildar. Lordship, assistant commissioner in hierarchy, I will show regulation 3. He is a superior officer to that of Tahsildar.
So what has happened after this consequence?
No, sir,
After this rejection?
I find this read, the interim protection with the coordinate bench granted by directing the authorities here conferred to my client. It's operating till now. Lord would see the orders passed.
No, no,
there.
did you serve a notice of suit?
No, sir, I have straight away come to this writ court, Lordship. I have come to this court immediately after challenge. I was apprehending, Lordship, that they may
But
remove
I
me.
think you ought to have served a notice of suit if you are so inclined.
No, I can come back, Lordship, because.
So that's the process. That's the procedure.
Absolutely, it's a mandate, Lordship. Now, may I say one thing? Now, kindly keep this matter on Thursday. In the meanwhile, I've served the notice under 202 and I'll place it on record by way of a supplementary affidavit. Then I can seek for the benefit under 2027 and 8. Because fact remains, it's a government revenue land. So Tahsildar is the authority vested with the power to pass an order.
No, if it's by a senior officer, superior officer doesn't really affect the legality.
No.
Moreover, High Court has directed the respondent number 3 to dispose of the representation.
It was in terms of the High Court's
My
direction.
lord,
Yes.
So then there is no difficulty in that.
my lord.
But then he can, he has the authority, he's entitled to suit, isn't it?
No, no, once the issue has been decided by the High Court, then there is no, no, or not on the.
He directly
Territory-
disposed of the representation,
Yes,
that's
madam.
all.
Yes, my lord. And the representation, the decision has been taken by considering all the records and evidence and hearing the parties. After there is nothing much to
There is
decide.
jurisdiction to remove that within a time frame, 202(1). Where is that in the impugned order? Once you turn down the prayer of the petitioner, the order should contain a direction that the petitioner should vacate within such and such time. Where is that part?
That has not been issued, my lord. There is no threat for the petitioner in that case,
Yes,
since there is no direction to remove.
there was a direction to dispose of the representation.
Yes, my lord.
So that
That
has
is,
to be disposed of in its
yes, ma'am.
true letter and spirit, right?
Yes, my lord.
Once you refuse the claim of the petitioner,
Yes, ma'am.
you need to take further steps that you have
Yes,
not
ma'am.
taken.
That as per the law, the authority will take, my lord. Yes, ma'am.
You sit tight over it. You don't ask the petitioner to vacate.
My lord, that in the following process we will take, my lord.
The order is incomplete. The order is incomplete. Once you
Then what we will
vacate
complete.
their claim,
Yes, my lord.
you have to ask them to vacate, right? And
Yes.
then they have a right to go before the civil court. So that process has not been followed. Have you issued any notice till date for their vacating?
No, my lord, there is no notice as on date. The notice has been produced by the petitioner also.
So let me discuss
not-
the writ petition upon holding all this.
My lord, my learned friend was asking about the report. Kindly see the inner page of the third, 3 of the order. Second paragraph. There is a report drawn point-wise in response to the written submission of the writ petitioner was submitted by the Patwari, duly endorsed by Tahsildar. In his comments, the gist of the which is reproduced below. So this is the report.
They made the report a part
This is the
of the impugned order. This
Yes,
is not the
yes.
principle of natural justice. If they want to rely it, they have to give beforehand to me in course of hearing, so that I can deal with it. I will take an exception to those reports. Then a decision has to be arrived at.
Have you given a copy of the reports to the petitioner? No.
My lord, it was heard and in before him only the matter was the opportunity was given to the petitioner and this order has been passed. There is not only for one time, there are 4 times the hearing was held.
Yes, but have you made over a copy of the report to the petitioner? You are relying on a report in your order.
My lord, it is also reproduced.
Yes,
It is also reproduced here, the report.
yes, in the order.
Yes, my lord.
But have you given a copy of the same to the petitioner?
That is not
Petitioner
appearing
should have
here.
taken the liberty to controvert it, isn't it? He could have filed an exception to the report.
It's not.
Are you asking for a reconsideration?
No, the matter needs to be revisited by this authority, my lord.
That's what I'm saying.
Not so.
And please give him the documents that you're relying upon.
My lord, now it is already there.
Yes,
On
but
record.
the result is already there out.
If this order
Yes,
goes,
my lord.
lordship, there is no report to everything goes, lordship.
You
As a
have
whole-
to
Now
give
they can,
copies of documents that you are relying upon.
Yes, ma'am.
The petitioner has not been able to produce any document, I believe,
Yes, ma'am.
before the authority, but you are
Yes, ma'am.
relying upon certain documents.
Yes, ma'am.
That the petitioner needs to know what documents you are relying upon,
Yes.
and on the basis of what documents you are arriving at a conclusion. I'll send this back for a reconsideration.
Yes, ma'am. Yes, ma'am.
The petitioner is aggrieved by the order passed by the Assistant Commissioner, North Andaman Subdivision, Diglipur on 10th June 2024, disposing of the representation submitted by the petitioner and petitioners and turning down their prayer for continuing in unauthorized occupation of government revenue land. That was your prayer, right?
Yes.
Paragraph. Heard learned counsels for the parties. Paragraph. The petitioners claim to be in occupation of the government revenue land for more than 30 years, you say, for more than 30 years.
Which we are disputing, my lord, in our,
Petitioners.
yes, ma'am.
And submitted a representation before the respondents requesting their continuation in the said land. The representation not being considered, comma, the petitioners approach this court in a writ petition seeking a direction upon the authority not to evict them without due process of law. Stop. By an order passed on February 5, 2024, comma, this court disposed of the writ petition, directing the respondent authorities to respond to the representation submitted by the petitioners and not to take any action against them in the form of eviction or any other penal measure till 3 weeks from the date the reasoned order is communicated to the petitioner. The third respondent in the writ petition was directed to afford an opportunity of hearing to the petitioners before arriving at a reasoned decision. Stop. Pursuant to the said order, comma, the Assistant Commissioner took up the representation for consideration and rejected the same. Paragraph. Though the petitioners were heard by the authority in disposing of the representation, comma, the authority relied upon a field inquiry report submitted by the area Patwari in turning down the prayer of the petitioners. Paragraph, learned counsel for the petitioners submits that that copy of the said report was not made over to the petitioners and the petitioners were not given an opportunity to contradict the same or explain their stand with regard to the report. Stop. It is not in dispute that copy of the report was not made over to the petitioners by the authority, though the said report has been solely relied upon by them in rejecting the prayer of the petitioners. In view of the above, comma, this court is inclined to hold that the issue is required to be revisited by the authority upon granting opportunity of hearing to the petitioners and making over copies of documents, including reports, relied upon by them in disposing of the representation. Let them reconsider.
My lord.
Paragraph. Accordingly, the writ petition is allowed. The order impugned dated 10th June 2024, passed by the Assistant Commissioner, North Andaman Subdivision, Diglipur is quashed / set aside. Who will deal with the the representation? The same authority?
Same authority. Yes.
He is a respondent in
In
this
this
third respondent?
That is.
The third respondent is directed to revisit the issue upon granting reasonable opportunity of hearing to the petitioners and also serving copies of documents proposed to be relied upon by him in arriving at a reasoned decision. Stop. The entire exercise should be completed within 3 months?
My lord.
Within 3
3
months
months.
from the date of communication of the order. Stop.
the interim, because if they take an adverse decision, I
Yes.
need some breathing time to challenge it, Lordship.
No steps shall be taken against the petitioners for their eviction from the property in question till 2 weeks after the order? Till 2 weeks from the date of the reasoned order.
I'm good.
Urgent certified.
Highly obliged, my lord.
I've already stated it. So I'm not going into 202 because
My lord.
we have not reached that stage.
The sir has not yet passed your yes.
Huh. Petitions and the
Both the matters by.
together.
Item 31.
My lord, that report has been filed, my lord, by way of affidavit regarding the leave encashment.
Yes,
My lord, that report, my lord, by way of affidavit has been filed, my lord, in respect of the computation of leave encashment. Rest of the matter, my lord, the petitioner, they are asking for interest because, my lord, the pensionary benefits were given to them to the person after the Supreme Court disposed of the matter. So now that has accounted because the parties were litigating, my lord, that has accounted for the delay. But they are now seeking interest for that period, my lord. This is on the aspect of leave encashment, but their other claim is in respect of interest.
the leave encashment part has been decided, right? You're only on the interest part.
Yes, I have got entire thing, I have got it, Your Lordship. But interest has to be given to me, Your Lordship, because for unnecessary, there is no reason for which it was delayed. They are saying that it is contemplated and all those things. This honorable court has come to a definite decision, Your Lordship, that I am entitled to get the entire retiral benefits and they cannot stop it. So they were holding my money,
That
Your
was
Lordship.
by an order of this court or the Supreme?
This court, they went up to the Supreme Court.
Where is the order?
Your Lordship, that is, I have annexed.
Why were affidavits required in this matter?
Lord,
Yes, it was not at all required, but.
they have
were
said that the
taking
leave
time and-
encashment has not been paid. That's why the court has said as to, no, they have not previously, that's why the earlier order, Honorable Justice
They were
Kaushik
disputing, my lord.
Chandra's order.
Part was disputed, that was paid later on.
So now it's clear.
Now it is
Look at the
clear.
interest
That's
part.
why the affidavit has been told us to file.
When did you return and when was it paid?
Yes, Your Lordship, dates I am giving, Your Lordship, just.
31st July 23,
Payment?
retirement.
Okay, I'm giving benefit.
31st July 23, retirement. Leave encashment was on 11 September 23 itself was done. But remaining retiral benefits were given subsequently.
Is I need to have the dates.
Your Lordship.
I'm just mentioning, I'm giving the date.
Juniors, they have missed the file, Your Lordship, I've written all the dates there.
Yes, please
Just
give me a
not
chart
take it-
of the,
yes,
a chart
thank
of the days, because it's on that I have to
Yes,
decide.
on the basis of
Yes,
that, it
yes.
has to be done.
Yes.
Tomorrow I'll give
She
you.
wants to come back tomorrow with the dates.
Tomorrow.
No difficulty.
Tomorrow dates I will do.
In fact, my lord will find all the documents, my lord, with that affidavit, my lord. But it's okay. Let them come back tomorrow, my lord.
Chart, if it is given, it will be easy, Your Lordship. We have to locate it, everything. So I will
Right.
get chart when it was due and when it was given, Your Lordship.
Do you agree to the interest part?
No, my lord. We were bona fide litigating, my lord, in the courts, my lord. So therefore, where is that? And this is not a matter for a writ petition, my lord, my humble submission, my lord. If there is, these are, my lord, monetary relief they are seeking, my lord. In
And
the
also,
form of
we cannot
interest.
say repetition. There are judgments.
Yes, my lord, they are, but in appropriate cases, my lord, because we were litigating bona fide up to the Supreme Court, my lord.
See, my money with you and you are getting interest toward that. Your Lordship, am I clear, Your Lordship? Because they were holding my
Absolutely.
money and in
That's
the bank.
that's
you
why
were
I'm
getting
asking for a
interest.
list.
Your Lordship, I get
18 June 2024, 18 June 2024, my lord, the amount of rupees 17,75,000, my lord, was sanctioned in favor of the petitioner. But
That
let
is-
them come back, my lord, let the petitioner,
We're over.
my lord.
Let her
Yes,
come back.
yes, absolutely.
I'll give advance to the other side so that if any discrepancy is there, he can clear it.
So then in that case, let it come next week.
No, let it be tomorrow.
No, we need to seek instructions from our client if to do what ma'am has indicated.
This week, Saturday.
Yes.
Ma'am, let it be on Monday, my lord, or Tuesday, whenever, so that we can, Rakesh he can take instructions from the client. Otherwise, my lord, we won't be, Saturday, they won't be working, my lord.
The documents, what is already
Well,
having
if
it.
they're asking for
Monday.
Monday, let it be
Monday.
Monday. By consent of the parties, let
Okay.
it be same heading on 4th, Monday's 4th.
My lord,
Above.
most good. Most good.
Your Lordship, page number 12, Your Lordship would show that I am the recorded tenant of these survey numbers, Your Lordship. Page number 12.
Yes.
Got it, Your Lordship. Now, Your Lordship, page number 13 is the map.
What are the survey numbers that you
Yes.
asked?
Your Lordship, 193/1/1. This is the subject matter, Your Lordship. 193/1/1. Now, Your Lordship, may kindly come to page number 13.
Yes.
This is the map which has been issued to me. Now, Your Lordship, may kindly see survey number 193/1/1. Just adjacent to that, one road is there. Footpath
Yes,
is there.
yes.
Now, the allegation of the Tehsildar is that I have occupied a portion of that footpath. That is the allegation. Now, Your Lordship, I will come to the notice order. Page number 14.
Yes.
Now, Your Lordship, whereas a complaint has been received from Shri Alok Mirda, Pradhan Gram Panchayat Shamnagar against Sunita Bare alleging illegal encroachment over a common footpath comprising line bearing survey number 193/1/9 situated at Krishna Nagar village. Now, Your Lordship, I am assuming that that particular footpath is survey number 193/1/9. And whereas based on the above complaint, a report was called from the revenue field staff, which revealed that the above said land bearing survey number this, measuring this, situated at Krishna Nagar.
You cannot have an interim order on 193/1/9.
I don't want, Your Lordship, but my case is completely different. What I am submitting.
And the
is-
subject matter is 193/1/9, which is not your plot.
Yes, Your Lordship.
So
but
please serve and come back.
I will, Your Lordship, kindly. Tomorrow is, they are going to demolish it.
They'll demolish this portion, not your property.
They are mentioning about survey number 193/1/9.
Yes, yes.
But in fact, they are going to carry out the entire activity upon my recorded land.
Where do you find that?
Your Lordship, may I submit, Your Lordship? Just one minute, Your Lordship. Kindly
You are illegally encroaching a portion of the footpath, you
That-
remove that.
That is allegations.
So if
No
you are not,
report, no survey,
if you are
nothing.
not encroaching, you have no headache at all.
Yes, Your Lordship, but they're trying
Because
to,
this is not a case that a part of your land is being taken away.
Your Lordship, they are going to demolish the structure which is lying on my land by
No.
stating that it is on footpath. Your Lordship, just 2 seconds I'll take. What happened thereafter? This is the order. Your Lordship, this
I'll
is
grant an interim order on your land, making it clear that they can take an eviction drive in 193/1/9.
Your Lordship,
I'll not stop that.
Your Lordship, they have not demarcated, they have done nothing. Direct order on the allegation of the Pradhan has been issued. Your Lordship, just 2 minutes, Your Lordship, I'll take. Your Lordship, then kindly pass the order. I will have no objection because, Your Lordship, just a minute. Your Lordship, what happened? On 7th July, my son received a notice. The story starts like that. That on 8th July is the hearing. I've specifically stated. Now, 7th July, when the notice was received by my son, it is in Havelock. My son is a person who is flying boats there. He took that particular notice and even he did not inform anybody. Now, 8th July was the date, immediately one day, just a day before the notice was issued. Then these people could not reach here and it was not even informed by the son. This particular order was pasted on the wall on 29th evening, stating that your thing will be demolished on 31. Breathing time was also not given. Then 30th July, they came here. After coming here, Your Lordship, I immediately, what I suggested to them, that if you have not been heard, and this is the story, you file a review application. I filed a review application today itself, in the morning.
Before the authority.
Your Lordship,
Before the authority.
before the authority, that I have not been given opportunity, I have not constructed anything, demarcation may be done in my presence. If demarcation is done in my presence, and if it is found, Your Lordship, that I am in occupation of the footpath, demolish it. I filed the review application, that opportunity of hearing be given to me. Even after receiving this review application, Your Lordship, they are saying that no, nothing will be done. It will be demolished. Tomorrow it will be demolished. Your Lordship, what my submission is that I am not asking that whatever I have constructed, if I have constructed on the footpath, it should be demolished, I'm saying. There are a number of decisions, Your Lordship, I cannot come in between that. But there has to be a proper demarcation in my presence. And the demarcation, if it is done in my presence with an appropriate authority, if it is found that it is on that particular land, it has to be demolished just on the allegation of the Pradhan that I have occupied, whether the Tehsildar, without conducting a proper demarcation in my presence, can pass an order, Your Lordship. I am asking this thing, Your Lordship.
I'll pass an order to that effect, that let there be a proper demarcation before.
In my
it is done.
presence, let there be demarcation and thereafter appropriate order may be passed.
Yes. The petitioner has assailed the notice issued upon her under section 104 of the
And
Andaman
moved,
and
Your
Nicobar
Lordship.
Islands.
Sorry for the
Yes.
intervention, Your Lordship. As per regulation 34, I can file a review application, and 35, Your Lordship, says the authority exercising the powers conferred by section 33 or section 34 may direct the execution of the order under revision or review to be stayed for such time as it may fulfill. Even a provision is also there. But kindly see, Your Lordship, the time period. Even breathing time has not been given to me so that I can take appropriate steps.
This shows it's a 24th July order.
Sir, I have specifically averred that it was pasted. Your Lordship, may kindly see.
Anyway, let me pass.
It was pasted like this on 29th evening. I have specifically pleaded in my writ application.
Yes, what did I say? By the Tehsildar, Sri Vijayapuram, under section 104 of Andaman and Nicobar Islands LR and LRR 1966. On 24th July 2025, directing her to vacate the unauthorized occupation over community land bearing serial survey number 193/1/9 of Krishna Nagar Village on or before 31st July 2025. Paragraph. Learned counsel for the petitioner submits that the petitioner has been occupying survey number 193/1/1, which is adjacent to the path in survey number 193/1/9. The earlier one is 1/1, this is 9, the last, yes. The petitioner apprehends that in the garb of demolishing the allegedly unauthorized occupation in survey number 193/1/9, legal construction raised in the petitioner's land shall also be demolished and the petitioner evicted therefrom. The petitioner filed a review application before the authority on yesterday.
Yes, today only.
Authority this day, which is yet to be considered. The petitioner seeks an opportunity of hearing before the authority before any step is taken by the authority for demolition of the allegedly unauthorized construction. Paragraph. It appears that the petitioner is in occupation of survey number 193/1/1. Survey number 193/1/9 appears to be a path adjacent to the petitioner's land. Since the review application filed by the petitioner before the authority is pending, this court directs the authority, being the Tehsildar, Sri Vijayapuram, to deal with the review application of the petitioner within 7 days from the date of communication of this order. The respondent authorities shall not take any steps with regard to survey number 193/1/1 occupied by the petitioner. Stop. However, they are at liberty to remove any unauthorized occupation, if any, in survey number 193/1/9 in accordance with law upon demarcating the said property.
This order, Your Lordship, but at some time being, this order is to be stayed, Your Lordship. Otherwise,
No, I will not stay the order. I've given specific directions. They can carry on the demarcations. They'll hear your review application, carry on the demolition work after demarcation. So that's clear. The order need not be stayed.
Your Lordship, the demarcation may be carried out in the presence of the petitioner, Your Lordship. That may be recorded. Otherwise, Your Lordship, it will be a formality.
Please read that part, demarcation part. The first any will not be there. remove unauthorized occupation, comma, if any, comma. Ah.
If it is specified,
Said property in presence of the petitioner slash her representative.
one thing can be done, Your Lordship, to protect my interest. This order may be implemented after this, after demand.
That means that whatever
Your
I've
Lordship, please,
stated.
I know about the Tehsildar, Your Lordship, we are facing that
No,
difficulty.
no, but seeing
No.
this, I know further
The
order.
problem that, Your Lordship, what they will say, as the order has not been stayed, we will do entire thing afterwards. But first of all, we will implement this order.
He'll
That they will
implement
say.
after demarcation. That is my specific order. I'll not stay there.
No, I'm not asking for stay. I'm just saying that.
I've stated that it will be done after demarcation in
Yes.
your presence.
That-
I've recorded that.
I think, Your Lordship, that is not there. The order.
Yes, I've recorded that. Please
The-
read out that line. However, her representative. That's clear. I'll not stay there.
Yeah, Your Lordship,
I know you're harping on stay. I'll
No,
not.
no, I can understand.
Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the respondent and file affidavit of service on the urgent date. Paragraph, let the matter appear under the same heading next week.
Your Lordship. Your Lordship, if that is mentioned, Your Lordship, that however the order may be implemented.
Yes.
After that word is used, Your Lordship, I will be very.
No, you will not be because
Otherwise-
they'll implement it after demarcation.
That may be mentioned, Your order
I've
may be
mentioned
implemented.
that.
Your Lordship, however, the demolition, Your Lordship, the word is used in that way. But these people, they will not understand, Your
The
Lordship.
order is.
However, if the order is implemented, Your Lordship, kindly, Your Lordship. I know about,
Do that.
kindly, Your Lordship.
However, the respondent is at liberty to implement the order impugned
Your Lordship.
in respect of /9. Subject to the remaining part will remain.
Yes.
After demarcating the. Yes, the property, not so property, the property.
Your Lordship. Deeply obliged, Your Lordship,
Um,
deeply obliged. I
when-
troubled Your Lordship. I'm
No,
sorry,
not
Your
at all.
Lordship.
Wednesday?
Your Lordship, Wednesday. I'll give the copy and everything.
Yes, that's 6th August.
Your Lordship. Your Lordship, wait.
Short matter can
It
be.
will be
disposed of.
uploaded, Your Lordship. Otherwise, I will be
Parties
asking for
factors
the
are
plain
copy.
copy.
Yes, it will be uploaded today.
Yeah.
Please give it to me first. On this
Yeah.
matter.
Deeply obliged.